We have just a couple minutes left, and then we will get started. And I do ask everyone to go ahead and mute their phones or their connecting computers, please. Okay, I have 1:30, and I see that we are not having our technology problems that we were earlier. So thank goodness for that. Let's go on the record. Good afternoon. My name is Charles Thatcher, and I am the regulatory law judge presiding over this hearing. Today is April 21st, 2021. The Missouri Public Service Commission has set this time for an evidentiary hearing in file number EO-2020-0227, captioned "In the matter of the second prudence review of the Missouri Energy Efficiency Investment Act, MEIA, Cycle 2 Energy Efficiency Programs of Evergy Metro Incorporated, doing business as Evergy Missouri Metro." And since we are in a WebEx hearing, I do ask that everyone please mute themselves unless you're going to be speaking. We will be proceeding slowly because of that muting and unmuting. And I also always like to note at the beginning of my hearings, please do not engage in the chat function with WebEx. It is not private and it can become a part of the record. So please do not use that to communicate. Let's go ahead and have the attorneys introduce themselves. Let's start with Evergy, Mr. Steiner.
Thank you. Appearing on behalf of Evergy, Roger W. Steiner, 1200 Main Street, KC, Mo, 64105.
Thank you, sir. And Mr. Hack.
Mr. Hack will not be appearing today.
Thank you. Mr. Fisher.
Yes, Judge, on behalf of the two companies, let the record reflect the appearance of James M. Fisher, Fisher and Doherty PC, 101 Madison Street, Suite 400, Jefferson City, Missouri. I think I'm getting some feedback.
Thank you. We sometimes have that when someone else has their microphone on, but also has a speaker on in the background. It seems to have cleared up. Mr. Harden.
Yes. Thank you. Joshua Harden on behalf of the two companies with Collins and Jones PC, 1010 Foxwood Drive, Raymore, Missouri.
And I was remiss in stating that there are two cases here, EO 2020-0227 and -0228. The 0228 is for Evergy, Missouri West, and those two cases have previously been consolidated. Back to entries of appearance for staff, Mr. Keeble.
Yes, Judge, appearing on behalf of staff of the Public Service Commission, Jeffrey A. Keeble. My address is 300 Madison Street, Jefferson City, Missouri, 65201.
Thank you, sir. And
When
for
we're
the
talking,
Office of the Public Counsel, Mr. Hall.
Good afternoon, Judge. Thank you. Caleb Hall, appearing on behalf of Missouri's Office of Public Counsel. Our office address is 200 Madison Street, P.O. Box 2230, Jefferson City, Missouri 65102.
Thank you. And I have a couple preliminary announcements on exhibits. I was looking over Mr. Hardin's exhibits that he had emailed to everyone, and it brought to mind that I did not see any of the MIA DSIM tariff sheets in the pre-filed exhibits. I was wondering if I could impose on staff, Mr. Keevil, to file the relevant MIA tariff sheets. I understand that there were also some that were rescinded or canceled during that time period. Is that a job that staff can undertake, Mr. Keevil?
We can, Judge. Probably not. Probably won't have them in by the end of today, but we certainly in the next few days can get them in.
That sounds perfect. I'm not going to set a deadline on that yet, just in case you could get them tomorrow before the end of the hearing. And just to share with everyone what I'm thinking about is Evergy Metro. It's sheet number 49 and its extensions. And then Evergy West, I had a little confusion finding that. I found sheet R-63, but that appears to relate to cycle 3. And the cycle 2 sheets appear to be numbered a little bit differently, and they start at R-75 and go on into R-100 and something. So I just wanted to make sure that the commission had those tariffs to review as they decided the case.
Judge,
and then lastly, yes.
Sorry, pardon me for speaking up at this time, but since we're on the record, it might, for the benefit of all parties, you might be right on the tariff sheet. I believe tariff sheets 1.04B through 2.34 are also part of the demand side management programs. And regardless, cycle 2's tariff sheets can be found on EFIS entry number 147 within the docket EO-2020-0227. I turned to the company to ask whether there may have been some intervening, or certainly there may be some cycle 2 tariffs that were not approved at the inception of cycle 2, but may have been in effect during the review period. So we would need clarification on that.
Yeah, I'm not positive. I mean, if we're looking for the existing tariffs that are in effect, I guess the commission could take administrative notice of that. And I think, Judge, you were wanting the West companion to the Metro sheet 49, and we can look up and see what that is. I don't know that off the top of my head, but it might be easiest just to take administrative notice of the tariffs that are in EFIS. Then no one would have to file anything.
I think you're looking at more than one
appreciate
sheet.
your suggestion and efficiency, but I would rather not take administrative notice. I would rather have all of the tariff sheets that were in effect at any time during the period, whether they lapsed or whether they were created. And I'd like that all in one bundle, one for Metro, one for West. And I thought kind of the best way to do that would be to ask staff, but if I know it's confusing, I tried digging through them. If you all would like to collaborate, that would be even better, but I do want to get that submitted. But I
Okay.
appreciate that I could take administrative notice. All right, last quick announcement. I scheduled our WebEx meeting to end at 5:30 today. I'm sure some of you noticed. I plan to end at or before 5. I, out of abundance of caution, scheduled the extra half hour for a just in case we had a little discussion going overtime. Does anyone else have any preliminary matters before we get started?
Related to that, Judge, I guess we still have the, I almost said still had the hearing room. I realize we don't have that. We're still on for tomorrow. Is that correct?
Yes, I have not created an invite or a WebEx meeting room for tomorrow yet. I was crossing my fingers that whatever happened this morning had cleared up. I was also hoping that lightning did not strike twice. So now that it seems to have all settled down and we all got into our meeting, after our hearing today, I will likely create a new WebEx meeting for tomorrow. And I'll send that out as soon as possible, or if we get a break during our hearing right now. Okay, let's go to opening statements. I believe Evergy was first.
Yes, Judge. I'd like to share a PowerPoint presentation with you. So let me see if I can get that to come up. Okay, do you see the PowerPoint on the screen? Okay.
We see it, Jim.
May it please the commission. Roger Steiner, Joshua Harden, and I will be representing Evergy Metro and Evergy Missouri West in this case. This case involves the second prudence review of the Missouri Energy Efficiency Investment Act programs for both of these companies. I think this is the first MIA prudence review case that has gone to a contested hearing. However, Evergy staff and the public counsel just completed a fuel adjustment clause prudence review case, file numbers EO-2020-0262 and -0263, which included prudence issues related to Evergy's management of the same demand response programs that are at issue in this case, and Evergy's capacity sales to third parties.
Mr. Fisher, I'm
Yes.
sorry, but I don't know what happened. My connection, I don't know. It said it was having trouble connecting to the network, and I lost you after you see the PowerPoint. I lost everybody.
Oh, I'm sorry. Well, we'll start again. Tracy,
Yeah,
if you lose anything, don't hesitate to stop me, okay?
Yeah, and if you see me go off of the screen, I am gone. I mean,
Okay.
because it blanked out, I don't know what happened there, but if I disappear, that means there's a problem.
Tracy,
All right.
can
So
you
you
try to
didn't
turn
hear
on your
anything
video?
on the record after I began?
Exactly. Everyone disappeared.
Well, Judge, with your permission, I'd like to just start again then.
You may, but let me ask Tracy one quick question. Can you turn off your video? That might save some of your bandwidth.
Okay. Well, I'm connected to a hard line, but I don't know. You
Oh,
won't
well, okay.
I mean, I don't know why it did that. It said it was an issue with the network, but not my internet. So I don't know. But I
Okay.
am happy to turn it off and we'll see what happens.
Up to you. Mr. Fisher, please go ahead.
Thank you, Judge. As I mentioned, Roger Steiner, Joshua Harden, and I will be representing Evergy Metro and Evergy Missouri West in this case. This case involves the second prudence review of the Missouri Energy Efficiency Investment Act programs of these companies. I think this is the first MIA prudence review case that has gone to a contested hearing. But Evergy, the staff, and public counsel just completed a fuel adjustment clause prudence case, which is file numbers EO-2020-0262 and -0263, which included prudence issues related to Evergy's management of the same demand response programs that are at issue in this case. And also Evergy's capacity sales to third parties during 2018 and 2019, and its capacity sales assumptions in the IRPs. The issue related to Evergy's management of its demand response program has been fully briefed and is awaiting a decision by the Commission in the FAC prudence review case. On the capacity sales issue, the Commission accepted a settlement in the FAC case filed by Evergy, Public Counsel, and the staff. There are 3 issues in this case which were not addressed in the fuel adjustment prudence case. Issues 2 and 3 relate to the prudence of the management of the residential programmable thermostat program and the demand response incentive program, respectively. Issue number 7 involves Public Counsel's allegation that Evergy's MIA administrative costs, or more precisely, its ratio of incentive costs to non-incentive costs in its MIA programs, is not consistent with other electric companies across the country. Unlike previous MIA prudence review cases, the staff and Public Counsel are proposing 3 disallowances which are beyond the scope of an appropriate MIA prudence review. I'd like to briefly address the appropriate scope of a MIA prudence audit, and then I'll discuss the merits of the staff and Public Counsel proposed disallowances. The company recognizes that there is considerable confusion over the appropriate docket to review the prudence of its MIA programs. The company believes that staff's recommended disallowances to the company's purchase power costs and SPP fees in this MIA 2 prudence audit should be made to the company's fuel adjustment clause if those disallowances are actually adopted by the Commission. Capacity sales revenues and SPP fees are recovered through the fuel adjustment clause and not the demand side investment mechanism, or what I'll call the DSIM. On the other hand, it's not possible to manage the MIA programs one way for the purposes of the fuel adjustment clause and another way for MIA purposes, as they are the same programs. Evergy believes that the audits of MIA programs should occur in the MIA prudence audit dockets. But if staff or Public Counsel prevail on any issue that impacts the company's fuel adjustment clause, then that adjustment should be made in the next FAC case. If, on the other hand, staff or Public Counsel prevail on any issue that impacts costs that are recovered through the DSIM, then that adjustment should be made in the DSIM in the MIA prudence audit case. Okay, turning to issue number 1. On July 29th, 2020, the company filed a motion to limit the scope of the proceeding related to 3 issues on the grounds that the disallowed costs were not subject to the demand side investment mechanism, or the DSI, as is required by the Commission's Rule 20 CSR 4220-20.093 subsection 11. On August 19th, 2020, the Commission stated in its order denying motion to limit, and I'll quote it, "Whether the alleged acts are costs subject to the DSIM is a question of fact in addition to a question of law." That's stated on page 3 of the order. And these factual and legal issues should be addressed in the hearing. According to the Commission's MIA rules, the appropriate scope of the prudence review in this case are costs that are, quote, subject to the DSIM. According to the company's tariff, the following items are included in the DSIM: the net program costs, the net throughput disincentive, net earnings opportunity, and ordered adjustments and corrections. And Judge, I'd point you to the KCPL tariff number 49I and J, and the GMO tariff number 138.2 and 138.3. There we go. Evergy's motion to limit the scope relates to the disallowances discussed in issues 4, 5, and 6 on the list of issues. On issue number 4, staff has alleged that Evergy's decision makers chose not to attempt to avoid Southwest Power Pool expenses by targeting demand response events and attempting to call events to reduce the monthly peak load. In this case, staff disallowed 1.1 million of SPP Schedule 1A and Schedule 11 fees on a combined company basis related to this adjustment. SPP Schedule 11 fees are those expenses that transmission customers with the SPP pay the transmission owners to build out the SPP transmission system. The regional portion of the Schedule 11 fees are allocated based on the company's load share or load ratio share. The load ratio share is simply the ratio of an entity's average of their 12 monthly peaks to the average of SPP's 12 monthly peaks expressed as a percentage. Again, the evidence will show that SPP fees are not collected through the DSIM, but are primarily recovered through the fuel adjustment clause and a smaller portion in the base rates established in a general rate case. That's related to issue 4. Now, on issue 5, staff has alleged that Evergy chose not to target demand response events in an attempt to reduce load during some of the highest day-ahead locational marginal pricing. The staff's proposing to disallow $140,530 on a combined company basis. The SPP market is comprised of a day-ahead and a real-time market. The day-ahead locational marginal prices are the prices at which Evergy is purchased and sold, at which energy is purchased and sold through the SPP market on a day-ahead basis. Staff has argued that Evergy should have attempted to use its demand response programs to reduce demand during the highest day-ahead locational marginal prices, with the goal to reduce the overall costs of energy. Now, as explained in the rebuttal testimony of Brian File, changes in SPP costs related to shifts in load during the SPP highest day-ahead locational marginal pricing would flow through the fuel adjustment clause and would not flow through the DSIM. Therefore, staff's proposed disallowance in issue 5 is not appropriate since these cost changes are not subject to the DSIM. Then on issue 6, staff has alleged that Evergy Missouri Metro did not enter into a hypothetical sales of its capacity to an unidentified third party in 2018 and 2019, despite being long on capacity. Staff has disallowed $1.2 million related to this particular disallowance. John Carlson, Evergy's senior manager of operations, testifies that the proceeds from capacity sales are not recovered through the company's demand side investment mechanism, but would be addressed in the company's fuel adjustment clause. There are no costs or revenues associated with capacity sales that flow through the DSIM, and there are no capacity related revenues that are, quote, subject to the DSIM or otherwise available to refund to customers from the funds collected by the DSIM. In summary, the evidence in this case will show that the SPP fees, cost changes associated with arbitraging the day-ahead locational marginal prices, and revenues associated with capacity sales are not, as a matter of fact or as a matter of law, collected through the DSIM. They do not flow through the DSIM, and they are therefore not subject to the DSIM. The costs and revenues associated with these staff adjustments proposed in issues 4, 5, and 6 would flow through the fuel adjustment clause mechanism or be included in base rates. I think the question for the commission in this proceeding then is whether any proposed adjustment in a MEA prudence case is permissible, even if the proposed adjustment includes costs or revenues collected through a different automatic adjustment clause, like the fuel adjustment clause, or in a general rate case. We don't think that's the intent of the commission's rules or the company's tariffs to allow just any adjustment in a MEA prudence case that does not adjust the costs and the revenues that were used to establish the DSIM rate in the first place. Now, if the commission finds that the company's management of its MEA programs were prudent during the audit period, which we believe the record was going to clearly demonstrate, then it'd be unnecessary to decide in this case whether the fuel adjustment prudence review case or the MEA prudence review case would be the appropriate place to do the prudence adjustment, because of course there would be no prudence adjustment. But for purposes of this case, the company would renew its request that the commission find that the proposed disallowances related to issues 4, 5, and 6 are not subject to the DSIM and are not appropriate adjustments to be made to the DSIM. Putting aside the question of whether these proposed staff adjustment disallowances are within the appropriate scope of the MEA prudence audit, I'd like to go briefly to address the merits of staff adjustments 2 through 6. On issue 2, staff proposes to disallow program costs of $866,000 on a combined company basis related to the residential programmable thermostat program that have been recovered through the DSIM due to the alleged failure of the company to alter the incentive level for the residential programmable thermostat program, and by providing thermostats to customers that did not enroll in the program. Staff also argues that Evergy could have avoided the additional cost of direct installations of thermostats and lowered the incentive amount of the residential programmable thermostat program by simply not giving away thermostats free of charge, even though that's exactly what the company's approved tariffs fully contemplate. And again, Judge, I'd refer you to KCPL tariff number 2.32 and GMO tariff number R-107. Staff's position on this issue should be rejected. First, the residential programmable thermostat program has been a success. Brian File's rebuttal testimony contains the specific levels of participation and the energy savings and demand savings for both companies. Secondly, the company followed the approved plan, which included giving away programmable thermostats, and managed the program within the budget by controlling the number of direct installations to a known level approved in the MEA program. Finally, the residential programmable thermostat program has been determined to be cost-effective by the EM&V evaluator and staff's own independent evaluator. On issue number 3, staff proposes to disallow $1.1 million related to the DRI program for commercial and industrial customers. Staff argues that Evergy entered into contracts for the demand response incentive program that did not incentivize meaningful participation and financially rewarded customers that did not participate meaningfully. On issue number 3, staff's arguments are again misplaced and should be rejected. Evergy followed the terms of the tariff and delivered the DRI program in accordance with the tariff. Customers who entered into agreements received the significant upfront payments approved by the commission. and customers who did not participate in the DRI were penalized at levels approved by the commission. Like the residential programmable thermostat program, the DRI program has also been determined to be cost-effective by the EM&V evaluator and staff's independent evaluator. Evergy reviews and meets at least annually with all commercial and industrial customers under the DRI program to discuss their participant performance. In fact, the company removed 16 megawatts from the program due to failure of customers to participate in 2018. The company also improved its realization rate performance from 2018 to 2019, demonstrating its efforts to obtain better performance from its customers in the program. For those reasons, the disallowances proposed by staff related to issues 2 and 3 should be rejected. Now, as I understand the staff and public counsel's testimony, issues number 4 and 5 go directly to their assertion that Evergy did not call enough demand response events, or what is sometimes referred to as curtailment events, during the audit period to maximize the benefits to customers, particularly reduction of SPP fees and cost changes related to arbitrage of day-ahead locational marginal prices. These issues have already been tried and fully briefed in the FAC prudence review case. However, I think I should briefly address these issues again to ensure the record is complete in this case. Demand response events are times when the company calls upon its commercial and industrial customers or adjusts the residential and business thermostats and essentially requests that customers curtail their usage to reduce the peak demand of the company using the residential programmable thermostat program and the demand response incentive program for commercial and industrial customers. Now, both staff and public counsel witnesses argue that the company should have called many more curtailment events during the audit period to maximize ancillary benefits by reducing SPP fees and attempting to reduce load during times of the highest day-ahead locational marginal prices. Now, in response to staff and public counsel arguments, Evergy would respectfully point out that the company's residential programmable thermostat and its demand response incentive programs were not primarily designed to save costs by reducing SPP fees or reducing load for energy savings at times of the highest day-ahead locational marginal prices, as is argued by staff and public counsel. The company's approved tariffs state that these programs were designed, and I'll just quote, to help reduce system peak load and thus defer the need for additional capacity. That's KCPL sheet number 2.32 and GMO original sheet number R-107. This is the primary purpose of the programs as defined by the tariffs. However, there will often be ancillary benefits of lessened SPP fees when a demand response event is called to reduce the annual peak. In fact, such ancillary benefits have occurred during the audit period under the company's MIA programs. As explained in the rebuttal testimony of Evergy witness John Carlson, the complexity of the SPP market requires not simply that Evergy pick the right day of the monthly peak, but it requires the right hour to accomplish the arbitrage strategy proposed by staff. This gamble must be made at 9:30 a.m. the day before the monthly peak and requires Evergy to reduce its bid into the SPP market by the amount of the energy reduced by the demand response event. Now, if the weather is not predicted correctly, or if there are other reasons Evergy's crystal ball did not work, then it would be necessary for the company to buy energy out of the real-time market to cover its load, perhaps at higher prices. The net effect could be costly to customers. Second, The company operates its residential programmable thermostat program and its DRI program to be consistent with the approved MIA tariffs, the approved MIA budgets, the MIA statutes and rules, and other commission-approved parameters. The MIA programs have been determined by the EM&V evaluator and the staff's independent evaluator to be cost-effective, and they've been within the commission-approved budgets. The company has also complied with the MIA 2 extension stipulation that was agreed to by Evergy, the staff, and the public council, and was approved by the commission. On February 15, 2019, the company, the staff, the public council, the Missouri Department of Economic Development, Division of Energy, and Renew Missouri entered into a stipulation which extended the MIA 2 cycle in case number EO-2019-0132. On page 3 of that stipulation, in paragraph B, these parties, including the staff and the public council, agreed to the following, and I'll just quote what's on the screen. For the programmable thermostat program, the company will call 5 demand response events per jurisdiction during the summer of 2019, parentheses, June through September, unquote. The commission approved this stipulation and ordered Evergy to comply with its terms. As a result, Evergy was required to call 5 curtailment events during the summer of 2019, and Evergy did so. The next slide shows the dates and the times that Evergy called the 5 curtailment events in the summer of 2019. Now, since the MIA 2 extension stipulation was entered into by Evergy staff and public council after the summer of 2018, there were no specific requirements agreed to for calling a specified number of demand response events for 2018. However, Evergy managed its demand response programs in the summers of both 2018 and 2019 as those programs were designed and approved by the commission to be managed. As I've already stated, the demand response programs in question were not designed to arbitrage day-ahead locational marginal prices or to reduce SPP fees through the calling of numerous demand response events, as suggested by public council and staff. To the contrary, the demand response programs were specifically designed to reduce the annual system-wide peak load, according to the company's tariffs. This is how those programs were designed. That's how they were implemented, and they were managed for both summers. In so doing, those demand response programs achieved the level of cost effectiveness sought by the commission via the methodology approved by the commission. Now, for example, in order to maximize the reduction of SPP fees, a MIA program would need to be designed to call multiple times every month of the year, since those SPP fees are associated with Evergy's monthly peak load in every single month, not just the annual summer peak month. A program that requires Evergy to call significantly more events to maximize the reduction of SPP fees would need a different program design, potentially higher financial incentives for customer participation, and would possibly need to be targeted to different customer types. Now, obviously, residential, commercial, and industrial customers do not prefer that their power be curtailed, but they're willing to occasionally accept this inconvenience for a financial incentive. But if the number of curtailments gets too high, these customers are going to decide not to participate in the curtailment programs. Now, staff and public council, unfortunately, don't seem to recognize this downside. And to the contrary, public council witness Mark suggests there are no downsides to calling as many curtailment events as possible. Signing up for a demand response program like the programmable thermostat program means that you're allowing the utility to make changes to your air conditioning load during typically the hottest days of the summer. This requires a significant amount of trust as well as financial incentives to manage your way through that inconvenience. Now, on page 7, lines 21 and 22 of the Sir rebuttal testimony of Dr. Mark, he testifies, and I'll just quote it, "There is also no reason that demand events could not be called every day. There is also no reason that demand events could not be called every day." Now, such a radical change in the design of the program would likely require increased compensation, and the participant pool will decrease significantly as the number of customers willing to give up control of their heating units and their air conditioning units year-round will likely be considerably lower than under the company's approved program. If customers were to start having their air conditioning adjusted very frequently, or even every day as suggested by Dr. Mark, the entirety of the program would change. The staff and the Public Council's short-sighted view on these programs should be rejected by the Commission. Now, the benefits from numerous curtailments are also dubious. Brian File discusses in his testimony the fact that the primary benefit from the MEA residential programmable thermostat program and the demand response initiative program is to lower the annual peak. It's not to maximize potential benefits of reducing SPP fees or lowering monthly peaks. As explained in that testimony, he indicates that attempting to maximize the ancillary benefits would likely reduce the benefit from the primary objective of annual peak reduction. Now, this slide that I'm showing shows the comparison of the Commission-approved value of demand response with the value of two other streams described by staff and Public Counsel in their testimony. If the company adopted the multiple demand response event approach being recommended by staff and Public Counsel, the company would be spending 90% of the event calls to achieve less than 6% of the value. The first event call results in the vast majority of the benefits. A 4-event minimum results in very small additional benefits, and a 10-event minimum results in only a sliver more of benefits. This is the very definition of the law of diminishing returns. The Commission should reject the staff and Public Counsel recommendations to accept the disallowances on issues 4 and 5, based on the theory that there should have been many more curtailment events called during the audit period. Turning to issue number 6. This issue appears to be a follow-up to the issue raised by the staff in the company's MEA 3 case, in which the Commission approved the company's MEA 3 programs, even though the company has sufficient capacity to serve its customers for several years into the future. In its amended report and order in the MEA 3 case, the Commission found that it was in the public interest to approve the company's MEA 3 energy efficiency and DSM programs, even though the company had sufficient capacity to serve its customers for several years into the future. The Western District of the Missouri Court of Appeals recently affirmed the Commission on all points. In this case, the staff is proposing to disallow $1.2 million because Evergy Missouri Metro did not enter into a hypothetical capacity sales contract with a non-affiliate in 2018 and 2019. Staff is under the mistaken impression that a ready market exists for unused capacity in the SPP footprint. The overriding assumption made by the staff is that capacity sales are easily made, that extra capacity can be sold by a market participant at any time. But staff is incorrect to make that assumption. As Mr. Carlson explains in his testimony, capacity purchases and sales made in the SPP market are bilateral in nature, meaning they are contracted between two counterparties outside of the SPP marketplace. Under other regional transmission organizations, such as the Mid-Continent Independent System Operator, or what we call MISO, or unlike MISO, SPP does not have a capacity market. And without a capacity market, market participants such as Evergy must canvass the market and find a counterparty that's interested in buying or selling capacity as needed. Now, Evergy routinely talks with other utilities, energy marketers, municipalities, independent power producers, and financial institutions to understand the needs of the marketplace, to be in a position to respond to requests for proposal, or to sell capacity on a bilateral basis to unaffiliated entities. In 2018 and 2019, Evergy Missouri Metro sold capacity to other entities who are identified in the confidential version of Mr. Carlson's rebuttal testimony on page 4. The company also continued to respond to RFPs in 2018 and 2019 as it had done for years. There are many factors, though, that affect the ability to sell capacity, including the supply situation and the needs of other utilities, transmission constraints, and the time periods needed to upgrade transmission facilities to serve those customers. Now, as the Commission probably knows, there's considerable capacity available in the SPP region today, given the relatively flat or declining load growth in the region as DSM programs have been implemented and appliances have become more efficient. Staff simply makes the inaccurate assumption that such capacity sales would be a buyer, they're at a particular price, that the situation was not impacted by transmission constraints, and it would be with particular terms and conditions agreeable to both buyer and seller. Staff's analysis does not suggest who the buyer would be, or even if there would be any buyer interested in Evergy's capacity during this audit period. It's based upon a hindsight review, and it does not meet the reasonable person standard for prudence reviews that is discussed in the staff and the company's testimony. The bottom line, just because the company is long on capacity does not always mean it can sell it. I'd encourage the judge or the commission to discuss with John Carlson how Evergy addresses such issues on its daily operations. Now, a similar issue and related issue has already been resolved in the recent FAC prudence review case. In that case, the public counsel initially argued that the company should have entered into capacity sales contracts with third parties, as staff is arguing in this case. In the alternative, the public counsel witness argued that Evergy should in the future include an assumption in its IRP scenarios that there would be no capacity sales. Evergy, public counsel, and the commission staff filed a unanimous stipulation which settled the issue. Evergy agreed to include a no capacity sales assumption in each of its IRP scenarios. On February 10, 2021, the commission approved the terms of the stipulation, which resolved the issue related to Evergy's capacity sales and the capacity sales assumption that would be used in future IRP scenarios. Now, turning to issue number 7. Public counsel witness Jeff Mark raised the issue of the level of Evergy's administrative costs related to its SBIA programs for the first time in his rebuttal testimony, and he suggested that they were out of line with other public utilities. However, as Evergy witness Brian File demonstrates in his testimony, Dr. Mark's analysis is an apples to oranges analysis and is deeply flawed. His argument is based upon a comparison of utilities of different sizes that categorize incentive and non-incentive costs differently. Public counsel's approach is not a good barometer to compare the various utilities' costs of providing energy efficiency programs. Now, a more appropriate way of assessing or comparing energy efficiency costs is on a dollar per kW or a dollar per kWh basis. When Evergy's programs are compared to other utilities using those yardsticks, Evergy's management costs are at or near the top quartile of the utilities across the nation. This means that 75% of other utilities operate their programs more expensively than Evergy for every dollar spent to achieve energy and demand reductions. Mr. File's analysis shows that Evergy's DSM program costs compare very favorably to other utilities in the country, as well as other electric companies in Missouri. This slide shows that Evergy's companies have lower overall cost per kWh than the national average and compare favorably with Ameren and Liberty. Similarly, this next slide shows that Evergy's have lower overall cost per kW than the national average, and again compare favorably to other Missouri public utilities. Staff witness Tandy testified in her testimony, and I'll just quote it: staff does not agree with the additional recommended disallowance of $1,930,392 for Missouri, for Evergy Missouri West is warranted for the review period. Dr. Mark's additional recommended disallowance is simply premised on arbitrarily reducing non-incentive costs to achieve a 50-50 split of incentive and non-incentive costs. Staff is of the opinion that this is a policy issue that deserves a more robust discussion prospectively outside of a prudence review to more appropriately determine how to address it. That's in staff witness Tandy's rebuttal on page 3. For all of these reasons, the commission should conclude that public counsel's analysis is flawed and the public counsel's disallowance should not be adopted. In conclusion, the evidence in this case will show that Evergy has managed its MIA programs prudently during the cycle 2 period. The company has managed its programs according to the commission's approved tariffs, and they've met the targets and the goals of the program within the prescribed budgets. The EM&V evaluators and staff's independent evaluator have determined the costs, or that the programs are cost effective. The staff and public counsel recommendations to call more curtailment events do not adequately consider the impact to customer behavior or to the impact on the company's ability to achieve the primary objective of its demand response program. The public counsel and staff recommendations do not consider the fact that Evergy was ordered by the commission to call 5 demand response events during the summer of 2019, and Evergy complied with this condition as ordered by the commission. Staff and public counsel's recommendations or recommended monthly arbitrage strategy is of itself imprudent and unreasonable given the design and the design objectives of the company's demand response programs, which is to try to reduce the annual peak demand. Finally, public counsel's analysis of Evergy's management costs associated with the MIA programs is flawed, and in fact, the administrative costs compare very favorably to other similarly situated companies. And for these reasons, the commission should reject the staff and public counsel proposed disallowances in this case. Judge, I'd be happy to answer your questions or questions from the commission. Thank you very much for your attention.
Thank you, Mr. Fisher. I would like to ask the commissioners if they do have any questions. Let's start with Chairman Sylvie. Did you have any questions? Commissioner Penny? Commissioner Roop?
I don't have any questions, no. Was well prepared. Thank you.
Thank you. Commissioner Coleman? And Commissioner Holzman?
No questions at this time. Thank you, Judge.
Thank you, Commissioner. I know we've been having some issues with the mute buttons, so Commissioners, I will invite you to ask questions. Next time for efficiency, I will just call for Commissioner questions and pause for a moment. Let's move on with opening statements to staff. Mr. Keevil.
Thank you, Judge. Can you hear me?
Yes, go ahead.
All right, thank you. First of all, I have to depart from my planned remarks just slightly and say that based on Mr. Fisher's opening, I was surprised to hear what he said in regard to issue 6 in particular, to the extent that he may have implied that issue 6 in this case was settled in the FAC case that was held a month or 2 ago. As far as staff is concerned, that case did not settle issue 6 in this case, and in fact dealt with a slightly different issue entirely. So the issue is still a live issue as far as we're concerned. I also am pleased to hear that the judge would like us to enter copies of Evergy's applicable demand response MIA program tariffs into the record, because hearing Mr. Fisher read from portions of the Evergy tariffs clearly involved selective reading of certain portions while not including the entire thing. So we will certainly be glad to provide those within the next few days, or as soon as we can get them together. Now let me get to what I plan to say here. May it please the Commission. I am Jeff Keevil, as you know, and I will be representing staff of the Missouri Public Service Commission in this proceeding. For background, and I think Mr. Fisher touched on this, and this may be the one thing I agree with him on, this case was originally 2 cases. File number EO-2020-0227 and EO-2020-0228. That was one case for Evergy, Missouri Metro and one case for Evergy, Missouri West. The cases were subsequently consolidated into file number EO-2020-0227 by order of the Commission. Both cases deal with the second prudence review of Cycle 2 costs related to the Missouri Energy Efficiency Investment Act for the electric operations of either Missouri Metro, Evergy, Missouri Metro, or Evergy, Missouri West for the review period of April 1st, 2018 through December 31st, 2019. These prudence reviews are required no less frequently than every 24 months by Commission Rule 20 CSR 4240-20.093 sub 11. Now, on June 30th, 2020, staff filed its reports in both cases, one for Evergy, Missouri Metro, one for Evergy, Missouri West. These reports are attached to the direct testimony of Mr. Brad Fortson, and the reports contained, among other items, certain recommended disallowances which were recommended by staff. Now, if you look at the reports, you will notice that they contain more recommended disallowances than those which remain for decision. This is because a unanimous, a unanimous partial stipulation and agreement, which was approved by the Commission on February 17th, 2021, resolved the disallowances related to administrative expenses recommended by staff. However, the stipulation and agreement did not resolve staff's recommended disallowances related to demand response or OPC's recommended disallowances. Now, at first glance, this case may appear to be somewhat complex. And certainly listening to Mr. Fisher's opening, you would think it's just tremendously complex. second prudence review of Cycle 2 costs related to the Missouri Energy Efficiency Investment Act for the electric operations of Evergy Metro or Evergy West certainly sounds somewhat intimidating. I'll grant you that. However, I would suggest that this case is simply a prudence review case, just like any other prudence review. Some parties may try to make it seem more complex than it really is, and you may hear several MIA-related terms used to make it seem like more than a simple question of prudence. However, at its core, the case is simply a prudence case. In State XRL Associated Natural Gas Company versus Public Service Commission, the Western District Court of Appeals quoted with approval the Commission's definition of the prudence standard as follows. A utility's costs are presumed to be prudently incurred. However, the presumption does not survive a showing of inefficiency or improvidence. Where some other participant in the proceeding creates a serious doubt as to the prudence of an expenditure, then the applicant has the burden of dispelling those doubts and proving the questioned expenditure to have been prudent. In the same case, the PSC noted that this test of prudence should not be based upon hindsight, but upon a reasonableness standard. In other words, the company's conduct should be judged by asking whether the conduct was reasonable at the time, under all the circumstances, considering that the company had to solve its problem prospectively rather than in reliance on hindsight. In effect, our responsibility is to determine how reasonable people would have performed the tasks that confronted the company. And if you want to look that up, that's 954 Southwest 2nd, 520, pages 528 through 529. In addition, the Western District Court of Appeals stated that to disallow a utility's recovery of costs from its ratepayers based on imprudence, the Commission must determine the detrimental impact of that imprudence on the utility's ratepayer. This is the prudent standard the staff has followed in this case, Evergy's allegations to the contrary notwithstanding. So based on this standard, the questions the Commission must answer are whether Evergy acted prudently or imprudently in its implementation of certain demand response programs, or by not calling more demand response events, or by not entering into a bilateral capacity contract. And if Evergy was imprudent, what adjustment should the Commission order? It's really that simple. Don't be led to believe it's more complicated than that. And I would also point out that just because Evergy got approval of the programs does not eliminate the requirement that Evergy implement the programs prudently. Staff's position is that Evergy was, in fact, imprudent and recommends disallowances on each of these bases as set forth in more detail in staff's statements of positions on issues 2 through 6 and staff's testimony, which will be offered fairly shortly. Staff's witness on its recommended, demand response disallowances is Mr. Jay Lubert. Also testifying on behalf of staff are Mr. Brad Portson, who is sponsoring staff's reports, and Ms. Cynthia Tandy, who will be staff's witness on issue 7 on the list of issues. Now with that, I will close my opening remarks and attempt to answer any questions you may have, or at least point you to the proper future witness. Thank you.
Thank you, Mr. Keevil. Are there any commissioner questions? Okay, I don't have any questions either. Let's move on. Office of the Public Counsel, Mr. Hall. Your opening statement, please.
Thank you, and may it please the Commission. Really quick before I begin, I just want to confirm, Ms. Taylor, are you able to hear me?
I am, thank you.
Thank you. My apologies. May it please the Commission. I want you to think about how the world talks about energy now. Think about the conferences you've attended and the technologies that you've been promised just over the horizon. The showrooms and the trade journals describing the grid of tomorrow. Then I want you to think about what you would do if you're in the position to control a utility's entire energy efficiency portfolio. You have the opportunity and the tools at your disposal to use demand-side management programs however you wish. Based on what you know, do you want to use those tools or not? And based on that, how do you want to run your operation? Do you want to invest more in your product or in overhead? Those two questions are at the heart of this MIA prudency review, and I think the answers are clear. A reasonable and prudent operator of energy efficiency programs would use what they have, especially after they ask for commission authorization to have those measures available. A reasonable and prudent operator would also employ a budget that prioritized muscle over fat, avoided costs and savings over administrative costs. This case exists because, per commission rule, staff conducted a prudency evaluation of Evergy's Cycle 2 programs pursuant to the MIA from April 1st, 2018 to the end of calendar year 2019. Staff has discovered that Evergy, despite spending ratepayer money to implement the demand-side infrastructure of smart thermostats throughout its service territory, has not been meaningfully calling demand response events using that infrastructure. Staff politely describes this as, quote, not maximizing customer benefits. That is a fair description, but I prefer to think of this as Evergy asked for money for a tool. They got the money and the tool, said the tool would be useful, and then didn't use it to what the tool could do. This is not prudent. It is not prudent to invest in energy efficiency if you're not going to use it without good reason. Let's look at the thermostat programs. In 2017, Evergy had already seen that its installation levels for its smart thermostats were far beyond what projections thought the adoption rate would be. Customers were taking the thermostats, and why wouldn't they? From the participant standpoint, it's free. It's being subsidized by non-participants. And from Evergy's perspective, Evergy's not out of pocket to provide the thermostats, and so the adoption rate skyrocketed. However, given the adoption rate, at any point from 2017 onward, Evergy had the knowledge that its incentive level was encouraging adoption faster than expected and spending non-participant money faster than necessary to put out the thermostats out. Evergy itself, in responses that staff has actually reprinted in its reports, stated that the company gave out over 2,000 thermostats over the review period and got less than 900 back from customers who didn't install them. This means that over 1,000 thermostats went out into this Evergy service territories and weren't being used to the extent they could to call demand response events. Looking at Evergy's demand response incentive program, again, customers were enticed to adopt demand-side infrastructure and to be available for curtailment. But Evergy gave customers incentives regardless of whether that DRI customer actually participated in the curtailment event. There were penalties for these customers that didn't participate, but as staff's report shows, those penalties came nowhere to matching or exceeding the original incentive amount, meaning that participants could make significant amounts of money simply for signing up for the program and nothing else. This is not meaningful energy efficiency, and at any point from the inception of Cycle 2 onward, a reasonable and prudent operator would see that its methods needed to change if it wanted to induce actual customer behavior. Then there's the nature of the Southwest Power Pool, or SPP. There's the nature of the Southwest Power Pool fees, which I will use the acronym SPP, and locational marginal pricing, or LMP. At any point in Cycle 2, Evergy knew or should have known that its demand response programs could realize savings for customers by minimizing coincident peaks and load periods during times of high LNP. We know that Evergy knows about this potential because the prospect of so reducing SPP fees and so taking advantage of LNP were two of the bases Evergy used to promote the continuation of these programs into cycle 3. And if they couldn't have realized those savings, they certainly could have at least tried. But from staff's reports, staff states that they found no such attempt from the part of the company. Evergy's response to staff DRs, which are again reprinted directly into staff's reports, state that Evergy did not consider bidding its contracted demand response capacity into the SPP market. Evergy actually goes so far as to say now to indicate that that's not even possible. If that's not possible to the extent that was promised, how does it make any sense to base cycle 3 on these savings that cannot be achieved? And there's more. On top of what staff found, OPC's chief economist, Dr. Jeff Mark, analyzed Evergy's overhead expenses and found that Evergy's management costs for these programs marks the greatest amount of non-incentive expenditures relative to incentive costs for any prudence review period in Missouri history. For the entirety of the MIA statute since 2009, over a decade, no other utility has come close to devoting so much of their MIA dollars into overhead and administrative costs. Jeff Mark found that Evergy Missouri Metro's administrative cost spending level is more than 17% of the national average for this ratio of non-incentive to incentive spend. For Evergy Missouri West, it's 21% higher. This national average, as reported by the U.S. Energy Information Administration, is a little less than 40% for the utilities that they reviewed. These were 600 different electric utilities across the U.S. who self-reported their data. Here's a key question. How much of Evergy Missouri West's energy efficiency program budget is devoted to non-incentive and administrative costs through this prudency period? The answer is 59%. And for Evergy Missouri Metro, it's 55%. More than half. Most. For both companies, most of the MIA dollars are going to overhead expenses. At this point, the question may occur to you. So what? 55 and 59 are just numbers. Consider that these are huge outliers even compared to the previous years of Evergy's experience. Despite building on the purported success of MIA Cycles 1 and the early years of Cycle 2, the administrative costs for Evergy have been increasing. In 2013, you had administrative costs for both companies at 31% and 46%. Forgive me, I forget which number is associated with which Evergy company. But from that low, it then increased to over half at what we're looking now in this review period. Consider also that Evergy and the Commission require program funds for the low-income weatherization program to limit those administrative costs to no more than 13% of total program funds. This limit makes sense because if you want the most bang for your energy efficiency buck, you're going to prioritize incentive and measure spend over padding administration. That same reasoning should apply to Evergy's overall MIA programs, not just the ones for low-income customers. Now, Dr. Mark is not recommending that we hold Evergy strictly to this 13% standard. Instead, Dr. Mark recommends an additional $1.9 million disallowance on top of the disallowances in staff's reports to account for this imprudent administrative expense. Disallowing this sum would place Evergy's non-incentive to incentive spend ratio at 50-50, placing Evergy more in line with the national average in terms of this ratio of overhead to program expense. The Commission should issue this disallowance in order to serve as a downward pressure on Evergy's administrative spending. If Evergy was in a competitive market, and had to promote its energy efficiency programs alongside competitors, Evergy would continually need to cut hairs, shave administrative costs, and perpetually pursue the goal of being better than the average. But we don't have that here. Evergy is a monopoly with a commission-authorized demand-side management program. And if we want this to get better, if we want the company to have a real financial incentive to correct this ratio of administrative to non-administrative costs, we need some type of force, outside force. And that force comes from the commission here. This case is where the commission can decide where the buck stops for both the disallowances offered by staff and OPC. Do we want to judge energy efficiency programs by whether they're going to be used or not? Are we going to judge programs based on how they can stay efficient or not? As previously explained, the Office of Public Counsel offers the testimony of witness Dr. Jeff Mark, who will be available to take any questions when he's called to the stand during this proceeding. Otherwise, I'm available to answer any general questions from the commission to the extent I can.
Thank you, Mr. Hall. Are there any commissioner questions for Office of the Public Counsel? Okay, and I have no questions. Let's move on to our first witness, and we will be going by the prearranged order provided by the parties. I believe the first witness is John Carlson of Evergy. Mr. Carlson, if you would say hello so we can identify you on WebEx. You're still muted, Mr.
My apologies. I thought I was unmuted. John Carlson with Evergy.
Thank you, sir. I'm going to swear you in, and then I'll ask your attorney to go ahead and begin with your questioning. Mr. Carlson, do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. And Mr. Fisher, go ahead.
Thank you, Judge. Please state your name and address for the record.
John Carlson, 1200 Main Street, Kansas City, Missouri, 64105.
Are you the same John Carlson that caused to be filed in this proceeding rebuttal and surrebuttal testimony in this case?
I am.
Do you have any changes or corrections that you need to make to that testimony?
No, I don't.
If I were to ask you the same questions that are contained in that testimony, would your answers be the same, and are they true and accurate to the best of your knowledge and belief?
Yes, they are.
Judge, I don't know if you'd like to mark those exhibits, perhaps Exhibit 3 and 4. And if so, I'd like to then have them marked and admitted into the record and tender the witness for cross.
Okay.
Mr. Fisher, could I ask a question? Yes, Mr. Fisher, did you say he had surrebuttal? Because I'm showing he had some hybrid thing called surrebuttal.
I'm sorry, that's correct, Mr. Keeble, you're right. It's called rebuttal. That was what we called it in this case.
Okay.
But it's there's two pieces, rebuttal and then the rebuttal. Judge, should I mark that, have that marked as 3 and 4?
Yes, I'll go ahead and take care of that. We have a slightly different system with our COVID precautions on taking exhibits. I will take the responsibility of submitting your exhibits and getting them marked. Are there any objections to the submission of Exhibit 3 and 4 offered by Mr. Fisher? Let the record reflect there were no objections. Exhibit 3 and 4 is admitted. The witness is tendered. Mr. Hall, your witness.
Thank you. Mr. Carlson, good afternoon.
Good afternoon.
Mr. Carlson, how long have you been working at Evergy?
A little over 15 or almost 16 years.
And what's your current role at Evergy?
I am Senior Manager of Market Operations. I believe Mr. Fisher said operations, but market operations.
Am I understanding that role correctly, that your primary responsibility then is to oversee the Missouri company's operations and daily submissions into the SPP network?
That's a fair statement, yes.
Given that role and responsibility, can you explain to me, in your testimony, you've referred to a monthly system peak. What do you mean by system peak?
So I believe in my testimony in that section, those sections, I was referring to the monthly peaks for the Evergy Metro and the Missouri West systems. There's also a monthly peak for the SPP system as a whole. So the monthly of the combined SPP entities, there's a monthly peak there as well.
How does the system peak relate to LMP?
That's a good question. I'm not sure there's a direct relationship between a system peak and an LMP. LMPs are based on the topology of the SPP system from a transmission and generation perspective, loads on the system, wind on the system. And system peaks are based on actual retail load from the entities within SPP.
So in your mind, the system peak is not when LMP is highest?
Not necessarily.
When is LMP the highest?
It could be at the high, well, to be quite frank, no one really knows from a market participant perspective. The LMPs could spike because a generator trips offline at a particular point in the system that causes a lot of system congestion and would ultimately cause the LMPs to spike. The LMPs could spike from a transmission outage that happens. LMPs could spike because of weather events causing an issue, storms coming in and causing transmission or system issues, wind dropping offline. It's not just based off of system load peaks, but it could be a multitude of system issues, and it could even be issues that aren't in or in around our territory. You know, so the SPP footprint goes from almost the Canadian border down to around Texas, over to mid-Missouri and out to New Mexico. So the system is very broad. There could be an issue in New Mexico that we don't even see here that could cause LMPs in the system to increase.
So, Mr. Carlson, do you disagree with, would you agree with me that locational marginal pricing is generally higher when the demand on the system is higher?
That's probably fair, yes. On an average basis, you could expect higher LMPs when demand is higher.
And so when people speak of peak demand, that peak demand often correlates with what can be the monthly system peak, correct?
It can, I'm sorry, could you restate that? I want to make sure I understood your question.
Sure. When people speak of, this is the problem with the vocabulary, I have to remember exactly what I said. When people speak of peak demand, would you agree that the times of peak demand often correlate with what can be the monthly system peak?
I don't know if I would use often. Quite frankly, I'm not sure if often is it more than 50% of the time. I don't know that for sure. Again, we could see a monthly peak in the Southwest Power Pool because other parts of the Southwest Power Pool have a high demand on load, whereas maybe in the Metro Kansas City area, we don't. There could be a cold front in Missouri, and it could be really hot in New Mexico and North Texas, where we have some SPP load that could cause the LMPs to increase.
But Mr. Carlson, will you agree with me that the logic of having a demand response curtailment event is that you're curtailing demand at a point where you could have high LMP?
I think the intent of our programs is to curtail when we have projected high demand, not necessarily high LMPs. If we were looking at our system peak, which our programs are designed to help reduce, that's what we're shooting for, trying to reduce those high peaks.
Do you think that if Evergy calls more demand response events, that it would be more likely to hit the system peak for a month?
Perhaps. I say that because there are some months that it is really difficult to determine a monthly peak. In the early parts of summer in June, you get some days that are really warm, you get other days that are really cold. So trying to nail down the exact hour of when a peak occurs is very difficult. It's marginally easier later in the summer when we have an approximation of when system peaks might be. Typically later in July, August timeframe is when you kind of see that system peak. But even then, it's not a given.
I want to make sure I heard you correctly. Were you saying that you're more likely to hit your peak in the summer?
We are a summer peaking utility, and by utility I mean across both Metro and Missouri West. We still have a summer peak.
Sure. And so if Evergy called more demand response events, let's just limit to summer then. Do you think you'd be more likely to hit the monthly peak then?
Yes, that's a fair statement.
And if you are more likely to hit the system peak, are you more likely to save on SPP fees as well?
Let me make sure I understand the question. You're saying if we called more events and potentially hit the system peak, we would save more on SPP fees?
Correct.
I believe that is correct. We could save more than we already are on SPP fees, yes. By the very nature of our programs, if we call an event, we are saving SPP fees. We're saving them now with the events that we've called.
Thank you. Mr. Carlson, I would like to get like a really bare bones understanding of how your group interacts with Mr. Files' group. So, is it fair to describe your group as the power purchasing team?
So my group, we offer in our generation to the Southwest Power Pool on a daily basis, and we bid in our load. So to the extent when you say power purchase, we are buying our load from the Southwest Power Pool.
Sorry, pardon my interruption. How about this, Mr. Carlson? What should I call your group within Evergy?
You could call us power marketing, I guess.
Okay, Mr. Carlson, does the power marketing group engage with Mr. Files' demand response team?
We do during the summer.
My understanding is during the summer, you're meeting internally on a weekly basis. Is that correct?
That is our intent. There are times we have to maneuver that meeting, but it's approximately on a weekly basis.
And you'd usually meet on Mondays to gauge whether SPP is going to reach the system peak. Am I correct?
We meet on Mondays and discuss what that next week looks like. Do we believe could there be a system peak? Are there any factors on the SPP system that we need to take into account that we know of, that's publicly available information? Quite frankly, like I said, there are a lot of things we just don't know about and won't know about. Transmission outages. As a marketing person, I can't know about those unless they're public knowledge. So there's some things that come up that we just can't predict. But
Sure.
from a weather and a potential load perspective, yes, we're meeting on a weekly basis and trying to determine if we perceive that a peak could occur during that week.
How many months are there's 4 months in Evergy summer period, correct?
That's correct.
June through September.
That's right.
So then that you're looking at 16, at least 16 monthly, 16 weekly meetings, correct?
That's correct.
And it's these meetings where these are the meetings where you're deciding whether to call an event for the next week, correct?
We may not make the final decision on calling an event in that meeting unless there was a need in the day or two following that meeting. Typically, what we would do is discuss the potential forecast of load and/or temperatures on the system for that next week. And if we saw in one of the days after that meeting a potential need, we would typically have a follow-up meeting closer to that potential event to see if the load forecasts and the temperatures have indeed turned out to be as we had projected initially.
And so you mentioned a follow-up meeting. Does that always happens after your initial meeting, correct?
Not always. If it were early in the season and we weren't projecting a peak for that week, we may not have a follow-up meeting. We're typically looking at historical peaks relative to current projections to determine, is there a correlation in terms of how we can expect that peak to come in for the system? And then if there was a projected peak in that month, or in that week, then we would typically schedule a follow-up meeting if we thought there was a chance of calling in a demand response event.
So following the timeline then, assuming that you've met with Files Group on Monday, you decide to call an event, is there an internal follow-up meeting closer to the planned event to confirm whether you're going to have the demand response event?
There may not be a follow-up meeting. There could be some emails back and forth to make sure nothing has changed. I wouldn't say it's set in stone that we have a follow-up meeting every time there's a potential event.
But there is a check. But there is is it fair to say that there's a check-in? Is it fair to say after Evergy has decided to call an event, there's at least one check-in before you finally proceed to actually call the demand response event?
I would say that's more than atypical. That's typically what happens, yes.
Thank you. I have no further questions.
Thank you, Mr. Hall. And now we go to Mr. Keevil.
Yes, Judge, just a couple of questions. Mr. Carlson, how often does your department forecast the respective Evergy load?
We look at a forecasted load on a daily basis. We have an outside vendor that we currently use that forecasts load for the Evergy system.
And it's just done once a day, forecast-wise, for each Missouri Metro and Missouri West?
That's correct.
You mentioned something in your response to Mr. Hall there about the difficulty of forecasting. Let me ask you this. In your opinion, does the difficulty of forecasting the respective Evergy system peaks alleviate Evergy's responsibility to manage costs prudently?
I'm sorry, can you restate that? I want to make sure I understood that question.
Yeah, just because it's difficult to forecast system peaks, does that alleviate or eliminate your company's responsibility to manage costs prudently, in your opinion?
Your Honor, I would object. I think that calls for a legal conclusion.
Well, I don't think it does. I mean, he was talking about the difficulty of all the different things that went into forecasting in response to Mr. Hall's questions. And I think, I'm just asking for his opinion, whether that eliminates the responsibility to manage costs prudently, fuel costs. I limit it to fuel costs if that's.
Overruled. I'll allow Mr. Carlson to answer that.
So we should manage our programs efficiently, whether there's load forecast or difficult to project or not.
Well, you said efficiently, and I think my question was termed and phrased in terms of prudently. You would have the same answer, wouldn't it? You should be prudent whether it's difficult or not, correct?
Yes, I would agree with that.
Thank you. I don't think I have any further questions, Judge. Thank you.
Thank you, Mr. Keevil. Any commissioner questions? All right, the bench has a question. Mr. Carlson, can you tell me how many curtailment events were called? I understand from Mr. Fisher's opening statement and your pre-filed testimony, there were 5, and I can list off those dates. I'm looking for the breakdown of between the residential program and the DR program and between Metro and West. Can you answer that, or is that somebody else better?
Judge, that would be Mr. File. He would have that type of detail.
Okay, thank you.
Sure.
I don't have any other questions. Mr. Carlson, you are excused. If you would
Judge, Your Honor. Judge, I had just a couple questions on redirect, if that'd be appropriate.
I'm sorry. Go right ahead. Redirect.
Mr. Carlson, you had a discussion with public counsel regarding the system peak, and I believe you indicated that it's not necessarily the time when LMP prices are at their highest level. Do you recall that?
Yes, I do.
Would you explain to the commission why that's the case? Judge, I think I might have lost him.
Mr. Carlson, if you could hear us,
Like everyone went down.
please turn off. Perhaps if you turn off your camera, we could still hear you.
Mr. Carlson appears frozen. I'm going to give this about 30 seconds, and we were scheduled to take a break anyway. So let's see if Mr. Carlson logs on quickly here. Mr. Carlson, are you there?
I can't. I can come over there.
I think we're rearranging our seats, Judge.
I'm hearing that.
I think that we may have had some technical issues here. Yeah, come on over here. Yeah, we're going to play some. Mr. Carlson's coming over here to commandeer this screen.
Thank you, Mr. Harden. Tracy, our court reporter, please take note. Mr. Carlson will be testifying, but from Mr. Harden's connection. Mr. Fisher, if you want to repeat your question.
Yes, Judge. I believe I asked you, would you explain why that's the case, that just because it's the system peak doesn't necessarily mean you're going to have the highest locational marginal prices, and why that's the case?
Well, there are definitely hours during the year, or let's say the summer, for ease of argument, when temperatures, let's say temperatures and load in the Midwest and the Kansas City area could be relatively mild for that particular month. But if you have, let's say 600, maybe 1,200 megawatts of generation come offline somewhere else in the Southwest power pool, that's not related to our load in any way, shape, or form, that can cause the LMPs in the Southwest Power Pool to rise fairly quickly. Now, why does that happen? That could happen for multitude of reasons. Chief among them could be the need to bring on much more expensive generation to cover that loss of 1,200 megawatts of load. You could bring on natural gas CTs, oil-fired generation that's much more expensive than maybe a base load unit. And again, that may not have anything to do with our load in the Kansas City metro area.
Mr. Carlson, how hard is it to predict the single hour in any particular month where the LMP prices are going to be at their absolute highest level?
As I mentioned, there are so many dynamics to LMP pricing in the Southwest Power Pool. There are transmission issues that come up randomly. There's generation, as I said, that might trip offline. There's generation that might come online somewhere that wasn't planned for by SPP. So ultimately, coming up with the single hour on a monthly basis when LMPs are the highest is increasingly difficult. And I'll give an example. I think I wrote this in my testimony. We could have on a day ahead basis an expectation that temperatures are really hot. It looks like it's going to be a lot of load on the system, and therefore perhaps LMPs are going to be higher. We make an assumption, the day ahead numbers come in, but in actuality, in the real time, those LMPs drop off quite a bit. Now, if we ended up being short on that reduction and we had to buy some of that generation in the real-time market, we could end up spending more than a potential benefit was there. So it's not as easy as saying after the fact, these LMPs were high, we should have called an event.
Is that an example of this arbitraging of the local marginal prices that we discussed in our opening?
That is, yes, sir.
Is it more difficult to predict the highest locational marginal price on any single month than it is to predict the monthly peak itself?
I mean, we're kind of splitting hairs. I don't think it's easy to predict monthly peaks. We would have a general idea from a system peak perspective. A summer peaking perspective, as I mentioned, is typically in that late July, early August timeframe. When you get down to monthly peaks, it's even more granular than that. In particular, you're looking at June, for instance, is more difficult because it's a transitional month. So you're getting some cold days, some warm days. Likewise, September is in the same scenario. But LMPs are so varied due to the market dynamics that I would say those are arguably more difficult to pick the days and the hours when LMPs are highest.
Well, under Evergy's demand response programs, are you attempting to reduce those monthly peaks?
No, the GSIM programs are designed for reducing system peak, not monthly.
Is it your understanding that's been approved by the commission?
That is my understanding, yes, sir.
I believe you also had a conversation with public counsel about hitting the summer peak and saving SPP fees. Do you recall that?
I do.
When you hit the annual peak, do you typically save SPP fees?
We could save SPP fees on the annual peak, yes.
During this audit period, did you save SPP fees when you hit the annual peak?
In fact, we saved SPP fees for the 3 separate events that we had called. I believe it was 2 in KCP&L and 1 in GMO, although I might be switching those. But the net effect of our calculation was about $375,000 of savings due to Schedule 11 fee reductions and Schedule 1A fee reductions. But again, that wasn't the driving force behind these programs. It was system peak. Those were ancillary benefits that occurred because of us calling the events we called.
You were asked some questions about when you meet with Mr. Files Group. Do you recall that?
Yes.
Why don't you meet with Mr. Files Group in non-summer months to consider calling curtailment events?
Because the MIA programs were designed for as a summer peaking product and explicitly name June through September as the applicable months for those programs.
If you were to adopt the arbitraging strategy that's suggested by staff and public counsel, would that have to change?
If you were looking at it on an annual basis, yes, yes, it would. I guess presumably, if the programs were rewritten, if customer incentives were analyzed and customer participation analyzed and again those programs rewritten, I guess we could implement something like that in the summer. But you'd have to rewrite the programs for sure if you were looking at a program like that for the whole year.
Well, if you were going to call curtailment events every day, as Dr. Marcus suggested, would you be meeting a lot more often with the Mr. Files Group?
Yes.
Why would that be?
Well, we'd have to be determining the hours when we were going to call events, the jurisdictions, the type of programs. I mean, these are all parts of the discussion that we go through when we meet on a weekly basis. If we were calling every day, we'd be having some sort of a communication on a daily basis.
I think Mr. Keevil asked you a question about whether it would be prudent to do something. Do you remember that?
I do.
Would it be prudent to be calling curtailment events on every day through the year?
I don't think that it would.
That calls for legal conclusion.
I think he was allowed to discuss that before, Judge.
State the question again, Mr. Fisher.
Oh, I was just asking whether it'd be prudent to be calling events on every day of or curtailment events on every day of the year.
Yeah, Mr. Hall, we did kind of open that can of worms. I'll go ahead and let him answer. Overruled. Mr. Harden. Or I'm sorry, Mr. Carlson.
No, I don't think that would be prudent.
Judge, that's all the questions I have. Thank you very much.
Okay, I am going to very slightly shake things up. I have one more question I would like to ask Mr. Carlson that will, of course, reopen it to recross and redirect based on that question. Mr. Carlson, my question is, wouldn't it stand to reason that the more events Evergy calls, the more likely to hit the system peak for that month and save on SPP fees?
If we called more events on a monthly basis, then that would increase our likelihood of hitting a system peak and should reduce SPP fees more, yes.
Just foreseeing the potential question on the other side, has Evergy done any calculations as to the effect on its customers of calling more events?
I would ask that you ask Mr. File that. He's more involved with the customer program design than I am.
Okay. Thank you, and we'll go back to recross if anyone has any questions based on my two recent questions.
None, Judge. Thank you.
None, Judge. Thanks.
Thank you. Any redirect?
Yes, Judge, just briefly, I may have misunderstood the judge's question, Mr. Carlson, but I thought he asked you whether calling more events would you be more likely to hit the monthly peak rather than the system peak.
No, I asked about the system peak.
Okay, I'm sorry, Judge. I have no questions then.
Okay. All right, then we are going to take that promised break. My watch, it is 3:18. Let's beat back here, so to speak, at 3:30. 3:30, we are in intermission. Thank you all.
Hey, Judge, may Mr. Carlson be excused? Or do you want him to stay? I think he's planning to stay at least the rest of the day, but
It would be nice if you could stay, but everyone's had their shot to ask you questions. You're excused.
thank you.
Okay, we are in intermission, if that wasn't official before. Okay, I have 3:30. Let's come back from intermission and stay on the record. The next witness I have is Mr. Brian File from Evergy. Mr. File, are you on the line?
He is, Judge. He's going to use my computer.
All righty. Tracy, the court reporter, please note that Mr. File will be testifying from Mr. Steiner's login. Mr. File, would you please solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you, sir. And Evergy, your witness. You're muted, Mr. Harden.
Try again. All right. Thank you. Good afternoon. Mr. File, will you state your name for the record, please?
Brian A. File,
Great. And with whom are you employed, Mr. File?
Evergy.
And what is your position?
I am the Director of Demand Side Management Products.
Great. And what's your business address, Mr. File?
1200 Main Street, Kansas City, Missouri, 64105.
Great. And are you the same, Mr. Brian File, that caused to be filed in this case, both rebuttal testimony as well as sir rebuttal testimony?
I am.
Great. And do you have any corrections to that testimony today?
After some further review, I do, actually.
Great. Can you proceed to delineate to the commission what those corrections are?
Sure thing. Thanks for the opportunity. It's in my sir rebuttal, specifically starting on page 7. There are a series of 4 tables, table 3, table 4, table 5, and table 6. Each one of those tables has an error in the title. For example, in table 3, the first column says total cost per megawatt hour, MWH. That should be per kWh, kilowatt hour. And that's true for all the titles. In table 3, they should be per kilowatt hour. As well as table 5, they should be per kilowatt hour. And in tables 4 and 6, it says, for example, the first title says total cost per megawatt. It should be total cost per kW or kilowatt. And so that is true of both tables 4 and table 6, those titles. And then supplementary, there are a few numbers in the tables that we reviewed and found need to be updated as well. Would you like me to read through those?
Yeah, why don't you go ahead and do that, please?
Sure. I'll start with table 3, no updates. Table 4, there are 2 numbers that need to be updated. In the Missouri West row, you find that in the incentive costs per now kW, the number should be 288.09. Right now it says 367 2.24, so we're replacing that one. And in the other costs for that same row of Missouri West should be 380.60 instead of what it currently says is 240.05.
Great.
That's all for table 4. In table 5, there are 2 updates. In the column incentive costs for the EIA 861 average, which is the first row, for incentive costs per now kilowatt hour, it should say 0.12 instead of 0.20. And for other costs, it should say 0.8 instead of 0.1 or 0.01. I apologize. And finally, in table 6, for that same EIA 861 average, which is the first row of table 6, all 3 numbers in that row need updated. The first number should be total cost per kW of 895.65. The second number should be for incentive cost 552.34. And the third number in that row for other costs should be 343.31. And those are the updates to those tables.
Great. Your Honor, if you think it's wise, and I would actually be inclined to file a errata sheet on those changes. I don't know if you had thoughts on those. It was a fair number of corrections. So
Yeah, let's go ahead and do that.
Okay.
Mr. Harden, I won't have that due for at least a couple days. We'll discuss exhibits kind of at the end, but we'll have time to take care of that.
great. I appreciate it. Mr. File, did you have any further corrections to any of your testimony?
I do not.
Okay. So with those corrections, as you sit here today, would your testimony be true and accurate as when you filed, again, with those corrections being made?
Yes.
Very good. Your Honor, I tender Mr. File for cross-examination.
Thank you. And Mr. Hall?
Thank you, Judge. Good afternoon, Mr. File.
Good afternoon, Mr. Hall. Good to see you.
So here's some cleanup I'm hoping you can help me with. The demand response incentive program, that is the same as the business demand response program that Evergy is doing in cycle 3, right?
Those programs are essentially similar in terms of the fact that it's a commercial industrial programs that ask customers to curtail. Names different, as you noted. In cycle 2 is demand response incentive. In cycle 3, it's business demand response. The incentive structures did change between the 2 different cycles.
So unless the dates didn't match, if someone in this case was referring to the business demand response, they were more than likely referring to the DRI program from cycle 2, right?
I don't remember exactly when that reference was, but if they were referring to cycle 3, they were probably referring to business demand response. Cycle 2, demand response incentive.
Great. Do you have a copy of Mr. J. Lupert's rebuttal testimony available?
I probably can find it, but I don't have it readily in front of me.
Unfortunately, this question does require you to have it. If there's a way your counsel could help me, certainly get that to you.
Yeah, I'll get it to you.
Okay, is this the Sir rebuttal dated October 14th? Is that the right one from Jay Lubert?
I think it's 14th, but yes, October 14th.
October 14th, yeah, sorry if I misspoke there.
So I'm looking at page 3 of his rebuttal. I don't believe what staff has indicated is confidential need to be confidential. Can you speak to that and confirm whether, technically my question is compound. Can you speak to that and can you confirm whether this stuff, what is redacted, need remain confidential?
It looks like they marked it as confidential. Maybe is that to your point?
Yes.
Doesn't appear that there's any confidential numbers in there that I can see in looking at his page there.
Could you then turn to page 16?
Sure.
Same question. Need the text and number that has been marked as confidential remain confidential? Remain marked as confidential.
Can you remind me where that particular text came from?
At the risk of testifying from my seat, my understanding is that this came from Evergy's surrebuttal report, which was filed in Evergy's MIA 3 docket, EO-2019-0132. If you can't confirm that, that's fine, but I just thought I'd ask at this point.
Yeah, it doesn't look familiar as if I created or was a part of that, so I wasn't going to speak to it. That's the only reason I asked where it came from.
But if the commission wished to cite to what has been marked as confidential on page 3, that need not be confidential. It's the number that's the issue.
Back to the page 3, I'm familiar with that section that's labeled as confidential. I don't believe there's anything confidential if that was your back to your question.
Thank you.
Mhm.
Mr. File, help me understand the difference between calling an event for the different programs. For a demand response incentive or business demand response customer, when you quote call the curtailment event, that is effectively telling a customer to shut off, correct?
For demand response incentive program, the way we call events is we communicate with our participants who have a contractual agreement. They give us a list of contact folks to communicate with, and we let them know that we're having an event, a demand response event, and they go through whatever predetermined procedures are in place in order to respond to that event. So that can be, altering their schedule of production, for example. It can be reducing load through lights or HVAC usage. Very rarely does someone completely shut down during an event, just for clarification there, but they do alter their usage in order to respond to the event that they're under contract to do.
Fair enough. So it's more significant of a curtailment, though, than what a residential customer would do through their thermostat program, correct?
What do you mean by more significant?
So assume I'm a customer participating in Evergy's thermostat program. If you call an event through your thermostat infrastructure, you are altering my thermostat by 3 degrees, correct?
There's a protocol that we set that allows us to cycle the air conditioner compressor, which tries to stay within a temperature band that can be up to 3 degrees. So that's, I think, what you're asking there.
Right, and that is, would you agree with me that's far less significant than the curtailment that you'd see in the DRI program?
I would say part of the reason I asked for the clarification is on an individual, we get less KW reduction from a one house than we do usually from a DRI contract. If you think about a commercial industrial facility and all the load that's there is quite a bit more than an individual customer. So you have to have a lot more residential customers to equal a C&I customer, if that's kind of where you're going.
No, that's exactly. Thank you, Mr. File. So focusing on the prudency review period we have now, am I correct that Evergy called 2 curtailment events using the residential thermostat demand response program in 2018?
Yes, we called 2 of our thermostat program events in 2018.
Does that include a test event?
We did not call a residential test event in 2018.
How do the numbers compare for your demand response incentive program in 2018?
We called 2 events in 2018 for demand response incentive, the commercial industrial program, with a test event in addition. And test event, is it worth clarifying what that means to us?
No, I don't have that question pending. Thank you, Mr. File.
I would like to know what a test event is, please.
Sure. So a test event to us means we send out the notification to customers to make sure they're receiving the notification in preparation for the season, right? Did all the texts go through and the emails to the right people? And then we have the participants go through their procedures, either in actuality or just through in the test process to make sure they can go through and activate for the actual event. And then we can watch their load change, after the fact, and we can tell them how they're doing, make sure we validate all this stuff so that when an event does come, they are ready, right? They've been through this process.
Thank you. I apologize for the interruption, Mr. Hall. Go ahead.
Not at all, Judge. So from 2018, we had 2 curtailment events for residential thermostats, 2 plus the test event for DRI, and in 2019, you called 5 thermostat demand response events. Is that correct?
Correct.
How does that compare? How many DRI events did you call in 2019?
We called 1 test event and 1 actual event.
Around what time? Were these events called around the same time each day?
For which period are you asking about?
Oh, in 2019, were the events called around the same time each day?
Similar times. The event on July 18th in 2019 both encompassed the 4 to 5 time frame, which is an important part for our system annual peak, in terms of where we usually hit our peak hours, usually.
Okay, so actually, to get further, what I'm trying to get at my question, you've reprinted the dates and times for when these events were called on page 11 of your SIR rebuttal, correct?
The SIR rebuttal?
Sorry, your rebuttal testimony, my mistake.
I do have that. Hold up. I have the dates and times of the thermostat events, the 5 thermostat events in 2019.
Cool. Based on my conversation with Mr. Carlson, I understand that your group is meeting with his group to decide when these events would be best be called. From that, you agree then that Evergy didn't call these events at any random time, right?
Correct. These were not random times.
And this is because, would you agree then that these times, it's not random and there often happens to be irregularity? 4 out of 5 of the events were called between 4 and 6.
Yes, the 4 to 6 time is an important time for hitting system peak, and so that is not random, correct?
Because we're in Missouri and it's in summer, it's gonna be hot and humid, and so that's when you're getting a lot of demand in the late of the day when everyone's turning on their air conditioner, right?
That typically drives some of the residential peak load, correct, in the afternoon.
How does this timing compare in the 2018? Do you see similar grouping?
Of when we called events?
Yes.
Similar.
Thank you. And for 2020, I'm curious, how many events have you called in 2020 for either your residential, for both your residential and your business demand response programs?
I'd have to look exactly when the times are, but as I recall, we called 2 events in 2020 summer season.
from your recollection, was the timing of those two events similar to the timing for these 2019 events?
That's probably a fair estimation, but I can't recall off the top of my head. Again, I'm trying to align with the system annual peak.
Thank you. I have no further questions.
Thank you, Mr. Hall. That takes us to Mr. Cable.
Yes, Judge, I'll have a few questions here if I can figure out how to operate my computer.
Hello, Mr. Cable.
Let's see. Okay. Can you hear me all right, Judge?
I can.
Okay, good. Mr. File, there's been a lot of talk so far about Evergy's primary objective with its MEA programs being to lower the annual peak. But I believe it was lower the annual system peak. Is that correct?
Correct.
Okay. Did Evergy call demand response events that coincided with the Evergy Metro and Evergy West, respectively, system annual peaks in 2018 and 2019?
We believe that in looking back at the season peaks, we impacted the season peaks in 2019 on this specific day to drive value. In 2018, I can't remember that one off the top of my head, but I think it was the second highest peak day.
So is that a no or yes?
It's both. 2019, yes. 2018, second highest, is my recollection.
Okay, what, excuse me. What date and time did the system annual peak occur for Evergy Metro in 2018?
I do not know that number.
Okay. What date and time did the system annual peak occur for Evergy Metro in 2019?
I believe that was July 19th, hour ending 5 p.m.
Okay. What date and time did the system annual peak occur for Evergy Missouri West in 2018?
I do not know that date off the top of my head.
Okay. What date, you probably know the next question. What date and time did the system annual peak occur for Evergy Missouri West in 2019?
I don't know that date off the top of my head either.
Oh, you didn't? Oh, I thought you'd know that one. Now, since you don't know several of those dates, do you know if Evergy provided those dates and times in response to data requests staff submitted in this case?
I can't recall if that question was asked or not. This case has been going on a while. I apologize.
Okay. Let's see here. Are you aware that for 2018 and 2019, Evergy managed to call one event at the hour of annual system peak? You got one out of 4 for Evergy Metro and 0 out of 4 for Evergy West. Does that sound right?
Remind me what the 4 are for each jurisdiction. I'm sorry, I wasn't quite following.
Oh, that would be the month in the program.
Are you referring to monthly peak? Is that what the question was? I apologize.
No, it's the annual system. Judge, I had hoped not to have to introduce this. I have a data response here that I would like to, I guess, submit. I could email it to all the council and yourself. Will that work for purposes of getting this in before Mr. File?
Yes, let's go ahead and distribute it and we'll see where we're at.
Okay, now where's your last email? Here we go, let's try this.
Mr. Keeble, have you sent the data request to us
No,
yet?
just now, there it goes. I was looking for a good email to attach it to. And Mr. Harden, you should be getting a copy of this, and I think Mr. Steiner will also. So you can give it to Mr. File when it gets there.
It just came through.
Okay, good.
Okay, and I've forwarded that on to the commissioners and advisors.
Mr. File, do you recognize that? Oh, Judge, I guess I should have it marked, right?
I'll go ahead and mark it now, and we aren't going to admit it into evidence until after we establish a foundation and ask everyone else.
Okay.
But let's go ahead and I'll mark this. What were your exhibit numbers for staff? It was,
I think I started at 100.
Okay. All right, go ahead, Mr. Keeble.
Is this number 100 then, Judge?
Yeah, let's start with 100. We'll give this one 100.
Okay, good. Mr. File, do you have a copy of what's been marked for identification as Exhibit 100?
Yeah, I just was able to open it in Word. I haven't looked at it yet.
Okay. Could you take a look at that and let me know if that looks like a Evergy response to data request number 64 in this case?
I'm flipping through this. It doesn't look like I was the actual respondent to this data request. So I can continue to read through that if that's helpful.
I would also suggest, Mr. Keeble here, I mean, this is not a simple response. We would need a little bit of time to review what is in this. in order for Mr. File, or actually probably more appropriately, the person who actually provided the answer to this, to be able to speak intelligently about it.
Well, I don't see why. I assume Evergy didn't have anyone answering its data request that wasn't authorized to answer its data request. The answer there at the bottom apparently was provided by someone named Randy Spale. You know Mr. Spale, Mr. File?
I do know Mr. Spala.
Spala, okay, sorry. I just want you to look at that last table, if you would, Mr. File.
I see it.
Does that table there indicate that only one date and time was an event called coincident with the peak for Metro and West over the 2-year period of 2018 through 2019?
Yeah, this table shows, it says Evergy load during event hours, and it appears there's a designation for the date and time I discussed about July 19th, 2019 as an event that was called during the same system peak hour.
Right. Then if you flip back to the first page, excuse me, the first page of the data request, about the 4th paragraph under the response says the supporting data below regarding West and Metro jurisdictions for 2018 and 2019 indicate that in one of 4 instances, Evergy Metro in 2019 did call an event at the hour the annual system peak occurred. You see that, sir?
I do see that sentence.
Okay. So that tells me that in all the other events that were called, the peak was not, they were not called coincident with the peak. Would you agree with that?
I think what is maybe a miss here that if you don't live into the data well enough, and again, this is worth talking about some here, is calling the event on the same hour that ended up being the system peak just shows that you reduced the peak that amount on that day. But
Well,
what could also happen is if you call an event.
If you could stick to my question, I think it would be very helpful, and we might actually be able to move along. Like I said, if you hit it 1 out of 4, that means all the other times you missed it, right?
So I was trying to explain that would be incorrect fully.
So you did hit it. So when he says you hit it 1 out of 4, you hit it more than a 1 out of 4.
As I read that statement there, we hit it exactly the same time and date of the one that ended up being the peak, but we could have called an event on a day that would have been the peak, but we called an event and reduced the load to make it not the peak, if that makes sense.
Okay, we may get to that here in a second. Would you agree that Evergy did not call demand response events coincident with the annual system peak for each jurisdiction in 2018 and 2019?
I'm not following the question. Is that similar to the 1 out of 4 question you just had there? It sounded the same.
No, just take it on its face. Did Evergy call demand response events coincident with the annual system peak for each jurisdiction in 2018 and 2019?
Oh, like a yes or no question?
Yeah, if you pay attention, most of my questions are yes and no.
Okay, sorry, I'm having a hard time following. I apologize. So yes, we called it sometimes, and other times we didn't. So it's yes and no.
You called it once.
Correct. Back to the 1 out of 4 question that you stated, we called on the exact
Okay.
hour that ended up being the peak.
Didn't Evergy have the ability to call events on all of those dates while remaining below the maximum number of events possible?
We have an opportunity to call it during the June through September timeframe, yes. And we could have called at those dates.
You could have, okay.
Specifically, in hindsight, it looks excellent to call on those dates.
Mr. Fowler, you wait for a question, please, sir. That's how this works. If a demand response event is called coincident with the respective system annual peak, is it possible that there could be a new system annual peak on a different date?
Yes, I think that was proving the question that I was trying to explain before, right? That you can call it on a day that will force another day to be a peak. Correct. I'm agreeing with you. I was agreeing with you.
Thank you. And then if you have additional events to call, you could call an event on that subsequent new peak also, could you not?
I think that depends on how the math works out. If I'm happy to explain if that's okay, or I can leave it there.
How the math of what?
So how close the next day's peak is compared to the day that you called, and how much demand response assets you have to reduce the peak. That makes a difference of whether it's worth the call on that next following day.
Let me ask this. At a point in time when the demand reduction from the demand response programs are necessary to meet SPP resource adequacy requirements. You with me so far? Is it not likely that Evergy will need to call several events to ensure that the system peak is mitigated?
I think I'm going to disagree with what you said there. The system annual peak is one time, right? It only happens once by definition, if I understand your question correctly.
Well, yeah, this question is not necessarily, well, you could call, if SPP, let me ask you this, take a different angle here. One of the reasons to call an event would be if SPP resource adequacy requirements require you to call, right?
Do you mean operational issues with SPP and they ask us to call an event?
Yes.
When you say resource adequacy?
Yes.
So that could be a reason, yes.
So you could be calling events due to SPP's operational reasons, and you could be calling events due to your attempt to hit the annual system peak.
Correct. Those could be different reasons, yes.
Right. If I could have you turn to, I keep clicking on the wrong thing. I think this is your rebuttal testimony, Mr. File, page 7.
Okay, I'm gathering that here. Think I'm there.
Okay. Beginning on line 8, it states, and just follow along with me here, the programs were designed for 10 events maximum, paren, DRI, close paren, and 15 events maximum, paren, thermostat, close paren. Further, a program that requires Evergy to call significantly more events would likely need a different program design, potentially a higher financial incentive for customer participation, and would possibly be targeted to different customer types. The marketing and customer recruitment process was developed based on the approved tariff to encourage customers to participate in the event maximums described above. Now, is that your testimony, Mr. File?
You've read it correct, Mr. Keeble. Thank you.
And you're welcome. And you still adhere to this testimony?
Yeah, that's my testimony.
Okay. My question is, if the tariffs were developed, or excuse me, the marketing and customer recruitment process was developed based on the approved tariffs to encourage customers to participate in the event maximums described above. Those event maximums, that would be the 10 for DRI and 15 for thermostat, correct?
Those are the event maximums stated in that line 8 and 9 that you read. Yep.
So have you ever called 10 or 15 events since developing the program?
Not to my knowledge.
And I think you testified in response to Mr. Hall that 2018 you called what, two residential thermostat and 2 business DRI events. Is that correct?
I believe that was correct. I think there's been a little confusion in about 2018, but I believe that was correct, what you said.
Okay. And in 2019, there were the 5 residential and 1 commercial. Was that correct?
1 commercial in 2019.
Yeah. Okay. So how is that encouraging customers to participate in the event maximums contained in your testimony?
All right, the specific line on 13 and 14 from the testimony?
Yes.
I think maybe there's a word there that probably needs clarification, and it would be up to event maximums. We aren't telling customers we're going to call them the maximum number of times every time, but we tell them that is a possibility and that's what they're signing up for. And in order to have a clear, transparent process about what they're engaging with the utility, and we want to state that up front, but we don't state that we will call you and maximum up that event every year, which clearly we haven't.
But that's clear in the testimony. That's how the marketing and the customer recruitment process were developed, correct?
They were developed to communicate that we could call up to the event maximums.
Well, you're kind of changing the entire import of your testimony, are you not?
Maybe I'm emphasizing a different part than as it seems like maybe you're emphasizing. I apologize, but that's in actuality what happens, right? We say this is what the up to events can be as a maximum, but we are not telling customers we're going to call maximum every year.
I don't see up to in that testimony, though, Mr. Fowler, but you keep talking up to now. That, to me, is a significant change to kind of on spur of the moment.
Is there a question for Mr. File?
Well, would he agree or not that the words up to do not appear in that testimony?
They do not.
Okay. I think that's all I have, Judge. Thank you.
Thank you, Mr. Keeble. Any commissioner questions? Okay, I do have a couple of bench questions. Mr. File, I do want to revisit 2018. You said that you thought that there was some confusion. Can you break down for me how many, and I've been calling them the residential and the DRI. So how many for the residential, how many for the DRI, and break that down by Metro and Evergy West, please.
Sure. And I apologize about what the confusion was. I think maybe I was thinking about whether we could count a test event or not. And so that may have been part of the confusion. But for the residential program, we called both jurisdictions at the same time for 2 events, June 28th and August 6th. For the demand response incentive program in 2018, for both jurisdictions, we called 2 events on those same days, June 28th and August 6th. The test event was earlier in the year, and that was June 7th for demand response incentive.
Okay, and the events that you're listing for 2018, it appears obvious to me, but I want to state that does fall within the review period of April 18 through December 19. Is that correct?
Yeah, that's my understanding.
Okay. All right, and just to confirm, for 2019, I have 5 for the residential and 1 for the DRI plus 1 DRI test.
Correct.
Okay. Excellent. That takes us to any recross examination based on the bench questions. Let the record reflect, no one is volunteering.
Judge,
Yes.
Your
Mr.
Honor, my
Hall.
apologies for the delay. I did have a couple follow-ups based on the questions from the bench.
Please go right ahead. Mr. Hall.
Mr. File, you were asked about 2018. I'm curious about how that compares to previous years. My recollection is that Evergy used the thermostat program to call 8 curtailment events in 2016. Am I correct?
I believe that was 2016 that we called 8, correct?
And for 2017, my recollection is that Evergy called 3 curtailment events using the thermostat program. Am I correct?
Subject to check, I believe that's right. Don't know that number off the top of my head.
Do you happen to recall Evergy's experience calling curtailment events using the DRI program in 2016 or 2017?
I don't remember those numbers off the top of my head, number of events.
Thank you. I have no further questions.
Judge, I don't have any questions, but I forgot to offer Exhibit 100, the DR response into evidence. So I'd do that now.
All right, that is fine. Let me pull that up real quick. Are there any objections to the admission of Exhibit 100, which is a DR 64 response? Let the record show that I hear no objections. It is so admitted. Okay, and back to Mr. Hardin. Any redirect?
Great. Thank you, Your Honor. Mr. File, I would like to go back to the last topic of conversation you were having with Mr. Keevil regarding the up to issue, taking a look at your rebuttal testimony. And I believe Mr. Keevil had referred you to page 7. And
Yes.
so what would, can you flesh out a little bit for us, what would be the, why it would be important to educate customers on the maximum number of possible events, even if it was not the plan of the company to call the maximum number of events?
Mhm. I think maybe just to start, it's good business process, right? When you're communicating an offer or an engagement that you're going to get into a contractual specifically with these customers, you want to talk to them about what's possible and what you're really having them sign up for. And as written in the tariff for the DRI program, it states that we can call up to 10 events if needed. And so we communicate that to customers and make sure that they are aware of what the potential is during the season for calling events. But we then, also explain the primary purpose of this program is to mitigate system annual peak, which by definition happens once per year. And so we will attempt to kind of meet that primary objective, but there is a chance that it could be more if there's things like operational issues on SPP, as Mr. Keevil alluded to, that might be of need, that we could call more events of.
Great, thank you. So again, in your testimony here on line 8 and 9, where you postulate that the programs were designed for 10 maximum and 15 event maximum for the thermostat program. Do those indicate what the purpose of the program, what those programs were for?
The line is simply stating what those event maximums could be for the season. That paragraph and the following paragraph do not get into the primary purpose. In fact, it talks a little bit more about what would happen if we called significantly more events even than the maximum, and talks about some of that.
Okay. Now, I would like to go to this DR number 64 that was presented today.
Okay.
Down here on the first page, this probably is more for your lawyer's clarification than anybody else's, but the second paragraph, the supporting data below regarding West and Metro's jurisdictions for 2018, 2019 indicate that 1 of 4 instances Evergy did call an event at the hour the annual system peak occurred. Now, in your response to Mr. Keevil's question, and doesn't that necessarily mean that you missed 3 peaks? You were explaining how by hitting 1 peak, I believe you were then creating peaks at a different time. Can you explain what you were getting at in that answer?
Sure. Thank you, and I apologize for not explaining that well before. And actually, if you look into that data request 64, just now again, scrolling through it somewhat, it starts to go into that topic right after the part that talks about 1 of 4 instances. It says that even when you add back in the curtailment that we did request from customers and that they did respond with, that if you add that back to the actual peaks, those would have been peak days. So maybe I speak a little bit with my hands here and see if this works, but let's say here's your peak that we hit on some day, but because we called a demand response event day, it actually reduced it this much, right? That's what happens on the days you hit it exactly, right? But on some of those days, the number is it is here, right? It's less than what we just called, but because we called demand response, it actually made the peak lower than that number. So it forced the day to be a peak that we talked about as the actual peak. So again, partly it's a math equation to say, hey, we reduced the peak 10 megawatts, and the next highest day was only 4 megawatts away. So therefore, we actually clipped 6 megawatts off of the peak, if that makes sense. Spreadsheets is usually where we explain all that through, but it's sometimes harder for me to do it verbally. Apologize.
Okay. So oh, sorry. Did I interrupt somebody?
Yeah.
I've got no further questions for Mr. File, but before I forget, Your Honor, I would like to offer his testimony into evidence, which I believe that I had failed to do at the beginning. So this is his rebuttal testimony and SRSA rebuttal testimony of Mr. File.
All right. And remind me what averages it was starting at 0 to 100 or 1 to 100 rather. So with Mr. Carlson, we had exhibits 3 and 4. What numbers are these, Mr. Harden?
So this would be 5 and 6.
Okay. We'll take them together. Does anyone have any objections to the admission of exhibits 5 and 6 onto the record? Let the record reflect there are no objections, so admitted.
Judge, I had a question. Mr. Harden originally mentioned submitting an errata sheet sometime in the next few days. Will that be numbered? And if so, do you want to go ahead and give it number 7?
I'm seeing a nod from Mr. Harden. We'll give it.
That's fine with me.
And I had given him an out earlier on, and I'd like to make sure and honor that. We're not in a huge rush to get the exhibits because they generally time out with the transcripts. So if I'm happy to give you to the end of the day Friday, was my first thought, but we're not in any rush, so I'm happy to leave it open and we can decide tomorrow. I've already got a note written for me.
That's
Okay.
fine.
Okay, we'll move on. We won't forget about that. Mr. Fortson is the next witness I have. If Mr. Fortson could speak up so I can swear him in.
I'm here, Judge.
Thank you, sir. Mr. Fortson, do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. And the witness is tendered to Mr. Keeble. Go ahead.
And I'm sorry, since the witness's name isn't on here, would you spell your full name for me, please?
Yeah, it's Brad, B-R-A-D, Fortson, F-O-R-T-S-O-N.
Well, she took my first question, Mr. Fortson. Now I'm completely lost. I don't know what to do. Mr. Fortson, this is Mr. Keeble again. Having stated your name, let's see. By whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission as a regulatory compliance manager.
Did you cause to be prepared and filed in this case both public and confidential versions of direct testimony of Brad J. Fortson?
I did.
Do you have any corrections or additions you need to make to that testimony?
Yeah, I do. One very minor correction to my direct, bottom of page 2, footnote 2. At the end of footnote 2, where it says 2020, it should say 2019.
All right. Any other corrections or additions?
That's it.
If I were to ask you the questions contained in your testimony, would your answers today be substantially the same as contained therein?
They would.
Do you swear and affirm that those answers in the testimony are true and correct to the best of your knowledge and belief?
I do.
Judge, with that, I would like to mark Mr. Fortson's direct testimony, I guess 101, and that includes both public and confidential, so there'd be like 101 public and 101 confidential, and then tender the witness for cross.
Mr. Fortson have other testimony?
I'm sorry, Judge, what?
I'm looking real quick. Did he have any rebuttal testimony?
I don't think so, Judge. Mr. Fortson, you didn't have rebuttal, did you?
No, only direct.
Thanks.
Okay, I just want to make sure we didn't miss anything. Are there any objections to the admission of Mr. Fortson's direct testimony marked as Exhibit 101, both public and confidential, to the hearing record? Let the record reflect there were no objections. The exhibit is so admitted. Anything else, Mr. Keevil?
No, I don't think so, Judge. I'd tender the witness for cross.
Thank you, sir. And Mr. Hall?
I'm not opposed to
Does
going
OP
first, but I believe Evergy as the most adverse party would go first at this point.
I was just following the list that you guys agreed on, but that's great.
No,
Mr. Hart, are you ready?
Most adverse goes last, don't it?
Regardless, Evergy does not have any questions for this witness.
Thank you, sir. Okay, order of cross-examination I have for a staff witness, OPC, and then Evergy. And I'm looking at the amended list of issues, order of witnesses, et cetera.
Yes, I see that now. Pardon my confusion, Judge.
Not a problem. At any rate, it's your turn, Mr. Hall.
Very well. Mr. Fortson, good afternoon.
Good afternoon.
Mr. Fortson, as well as MIA prudence reviews, you also participate in the underlying cases for approval or rejection of MIA programs, correct?
I participate in the MIA application filings, yes.
And how long have you been doing that work?
That's a good question. I would say like 5 years.
Given that time, you've had exposure to the various cost effectiveness tests, right?
Yes.
When is cost effectiveness measured or tested for a MIA portfolio?
Well, for the MIA application, the companies typically file with their application cost effectiveness test at that time initially.
So that's done on the front end.
That's on the front end, yes.
And from your understanding, with some exceptions such as low income programs, a program has to be the MIA portfolio has to be cost effective to be valid, correct?
It's typically looked at as cost effective if with a TRC above 1. Yes.
And that's all on the and that's all on the front end of an app with the application and approval process.
Yes, if you're just asking about the application, yeah, that's on the front end with the application.
Yeah, I'm just trying to get, so you'd agree with me that's separate and apart from this stage and where we're at with the prudency review.
Yes, definitely.
Thank you. I have no further questions.
Thank you, Mr. Hall. That takes us to commissioner questions. Okay, hearing none. I do have several bench questions. Mr. Fortson, can you tell me how many events were called? And the same exact question I asked earlier of Mr. File. Can you break those down by year, by West versus Metro, and by residential versus DRI?
I apologize, Judge. I can't. I actually didn't take notes of what Mr. File was saying. I believe that has been stated in testimony. I believe Mr. Lubert, staff witness Lubert, has spoke to that in testimony as well. So he could likely have better or speak to that more so than I.
Okay. And Mr. Hall just asked you about the cost effectiveness test that is handed in at the application at the front end. Is that the same test as what I have been calling a TRC test? And I'm taking that acronym from the statute that says I think it's the total resource cost is the preferred test. Is that what we're discussing now?
That's correct.
Okay, so the TRC test is not done at all at the end?
Well, and to be clear, that's why I wanted to clarify with Mr. Hall. On the front end, it is the company does their analysis, provides that preliminary cost effectiveness with the application. However, after an application is approved, there is, as part of evaluation, measurement, and verification annually, those cost effectiveness tests are reviewed and updated by the third-party evaluator.
Okay, and Evergy has said, I don't recall which witness, but in one of the pre-filed testimony, they said that the third party and the staff consultant both found that they had, I guess, passed the TRC test. Is that correct?
That is correct, with maybe a slight clarification. There has been, over the years, some contentiousness as to what the benefits of those cost effectiveness tests are. Typically, costs aren't disputed, but what those benefits that they're compared to have been contentious. So the third-party evaluators, both for the company and for the commission, the benefits that are used are the benefits that are provided by the company. So they have confirmed cost effectiveness for those programs based on the benefits, the avoided costs that the company has provided.
Does that abide with the statutory requirement of what the test takes into account?
To some degree, the test takes into account avoided costs, both capacity and energy, and the cost, the program cost. Again, there's been some dispute as to what the avoided capacity costs are, but in general, it's the avoided costs and the program costs that are used for that test.
Has there been another cost effectiveness test that we could compare the statutory total resource cost test with something that might make up for the shortcomings that you're pointing out?
I don't think directly. We do also review and evaluate the UCT, the utility cost test, that takes the benefits, still the same benefits, with a different subset of costs. So typically we're just looking at the same benefits with potentially different costs.
Would you then say that the total resource cost test is not indicative of prudence?
I would say, I guess to answer that question, I would say that in my view, in staff's view, a program could be cost effective or could pass the TRC, be above 1, but still be imprudently managed.
Okay. Let's move on. I have several questions, and I'd like to get into The staff reports. So for everyone's information, I'm going to page 7, both staff reports, both page 7s. And I'm going to start with Evergy Metros. I happen to have it already on my screen, but I'll give everyone a couple minutes to get there, or a couple moments rather.
And Judge, you said page 7?
Yes. Page 7, and I believe it's table 2. Yeah, table 2. Oh, I'm sorry, page 5, page 5. My apologies, it's referring to 7 pages that I want to ask about. Okay, Mr. Fortson, on Evergy Metro staff report. So that is 0227, page 5. I'm sorry, page 4, the last sentence says, table 2 below identifies the line items and review period amounts from addendum A, which are the subject of staff's prudence review. I just want to confirm that that is a typo because there is no addendum A attached on this report. It is titled attachment A. So I just want to confirm that we're all talking still about the same thing.
I don't believe that's a typo. I believe what that is, and maybe it didn't get filed with my direct with these reports, but when the reports were filed initially in this docket, I believe there was a few addendums provided with that report. And addendum A, if the way the sentence reads, this is referring to addendum A, and these costs and these dollar amounts are straight from quarterly surveillance monitoring reports that are filed with the commission. It's the same format as this.
Yes, but what I'm getting at is, and then I just checked in both reports, the originally filed one and the one filed with your testimony, 227 does not have an addendum A. The 7 pages of the periodic reports that you're talking about are labeled as attachment A, and only in the report for Evergy Metro. The report for Evergy West calls them addendum A, and then the attachment is labeled as addendum A. So I'm really just trying to confirm that what is being called attachment A on the Evergy Metro report should really be called addendum A to match what it is referred to in the body of the report. Is that correct?
Yeah, I believe that is correct.
Okay. And both reports, Metro and West, I'm still talking about table 2. I believe all of these questions are going to be on table 2. The information from those addendums is for the prudence period of April 1st, 2018 through December 31st, 2019. Is that correct?
That's correct.
Okay. And on the Metro report, could you confirm the total program costs actual period total was how much?
So if I understand your question correctly, that would be the 25,869,310.
Okay. This is going to make sense in just a couple more questions. And just to state again, I'm looking at the title of the table, and it says cumulative totals for April 1, 2018 through December 31, 2019. I counted on my fingers earlier, and that was 21 months. My next question has to do with the next paragraph on that table, and it's called annual. And it also refers to first year. So can you tell me if the next line that says first year gross annual energy savings deemed actual is for the year or for the 21 months period?
It would be for the 21-month period. I understand the wording of it. Again, first year gross annual energy savings taken straight from those surveillance monitoring reports, but we will take those quarterly surveillance monitoring reports and add up the quarters within the review period to get a cumulative total.
And you did do that, is what you said?
Yes.
Okay. So when I read first year and annual, I can interpret that as for this time period of 21 months is what it really means?
Yes.
Okay. And total program costs, I just want to revisit that now that we've got the annual issue in there. The 25,869,000 number, that is representative of the 21-month time period. Is that correct?
That's correct.
Okay, same question on the throughput. I'm sorry, same question on the first year gross annual deemed savings.
Yeah.
It is also
same
for
answer.
the 21. I apologize, I interrupted.
No, that's okay. I was agreeing that is the same. It's for the 21 months.
Okay, and can you confirm the same 21-month coverage for the throughput disincentive costs?
Yes.
Okay. And would it be fair to understand all of these same conditions would apply to West's Table 2, the staff report of Evergy West, their Table 2?
Yes, that's correct.
Okay. And has staff considered the Evergy Metro residential customer rate that would have been charged for the actual kilowatt hours savings? For example, Evergy Metro residential customers without space heat pay a base rate of 0.14916 kilowatt hours, and that's in cents, in the summer for usage over 1,000 kilowatt hours, and that's taken from sheet number 5A. Mr. Fortson, do you know the dollar value of the kilowatt hour savings for Evergy Metro residential customers at that rate?
I think I followed your question, but I don't know the answer to it.
Okay, maybe one of your compatriots will have that when they come up to testify. Next question. Given that the Evergy West staff report table, oh, I'm sorry, I already answered that. Okay, and then I have a similar question for Evergy West, calculating those residential customers at the base rate for Evergy West. I'll ask that of other witnesses. Okay, that is all of the questions I have for Mr. Fortson. That circles us back to cross-examination. Does anyone have any recross?
The company receives.
None from OPC, thank you.
Mr. Harden, you were echoing. Was that a no?
That is a no.
Thank you, sir. All right, and redirect. Mr. Keegan.
Yes, very briefly, Jim, if I can, I'm echoing too here, sorry about that. Let me find my note. There we go. That should work. Mr. Fortson, the judge offered, asked you several questions about total resource cost test and cost effectiveness and things of that nature. Would you agree that the EM and V process assumes avoided capacity costs provided by the company to estimate the benefits and that they do not verify actual ratepayer benefits?
That's correct.
And can you distinguish between, I mean, I assume the one is an estimate, and that's because they use, or how do they come up with that estimate? Do you know?
For the avoided cost?
Right. That comes from the company, correct?
Yes, the company provides their assumed avoided capacity cost.
And so that's the assumed avoided capacity cost. And when we're talking about actual ratepayer benefits, that would be money or money that the customers either receive or don't have to pay as a result of the programs. Whereas the estimates are something completely different. Is that right?
If I understand your question correctly, the company provides an avoided cost that they use for their analysis. When it comes to actual customer avoided costs or those benefits, there's no real, in my opinion, there's no real way to determine what the actual customer benefit is. We use a proxy avoided capacity cost. We assume this to be the avoided cost or the benefits that customers will realize, but there's really no way to verify that those benefits are realized by the customers. And one thing, just to clarify, so just given the nature of MIA, so the costs are recovered by the company immediately, and the benefits that are, again, used in that cost effectiveness test are spread out and assumed for the life of those measures. So the benefits could be spread out over 20 years. So to say that customers actually realize those benefits is, in my mind, almost next to impossible.
And that's when you're talking about these benefits that are used under the TRC test?
Yes.
Now, do you know whether Mr. Lubert, another staff witness, has testimony on this particular issue?
Yes, Mr. Lubert has some extensive testimony on that issue.
Thank you. I think that's all I'd have, Judge.
Thank you, Mr. Keevil. Your timing is perfect. I note that it is 4:54, and we have completed all of Mr. Fortson's testimony. We are going to wrap up today. The rest of the witnesses can relax. We'll be called back tomorrow. Let's take care of a couple housekeeping items real quick before we shut down. I have not yet sent out the invitation for tomorrow's hearing. I've been here. So we will do that. I will do that hopefully immediately. And then please distribute that to all of your witnesses. We will begin at the same time tomorrow, 9 a.m., unless I hear objections. I don't hear any. 9 a.m. it is. And Mr. Lubert, is Mr. Lubert still on the line?
Yes.
Somebody can get a message. Oh, thank you, sir. Would you bring your calculator with you tomorrow when you come to testify?
I also have a question. What document were you referring to, Judge, when you asked Mr. Fortson a question about sounded like some rate that you had?
Some rates?
Well, you asked Mr. Fortson if he could calculate something. That he deferred it to Mr. Lubert, and I didn't know what you were referring to get the numbers, because I didn't see them in Table 2.
I hopefully will get an email explaining that shortly. What I'm referring to is for Evergy Metro, it's sheet number 5A, and for Evergy West, it's sheet number 146.1. And the rates, they come from the tariff.
Okay.
And the question is, I'll just repeat it so everybody can write it down, get prepared for tomorrow if you like. Has staff considered I'll slow down when I get to the numbers. Has staff considered the Evergy Metro residential customer rate that would have been charged for the actual kilowatt hours savings? For example, Evergy Metro residential customers without space heat pay a base rate of $0 period 14916 per kilowatt hour in the summer for usage over 1,000 kilowatt hours. And the question is, do you know the dollar value of the kilowatt hours savings for Evergy Metro residential customers at that rate? I think how much that rate would charge for the difference in what was lowered from the peak. But I'm not real sure. Accounting isn't my strong suit. The question for Evergy West is exactly the same. The space, customers without space heat pay a base rate of $0.11927 per kilowatt hours.
I'm not sure base rates factor into this. Well, I guess. Okay, Mr. Lubert may have to explain that.
For tomorrow.
I was going to say, Mr. Lubert may have to explain that to us. And the other thing, when we started off the day, you asked for the MIA tariff sheets for both Metro and West that were in effect for the review period. I assume we're not under the gun to have that by, like close of tomorrow's hearing or anything, are we?
Nope. I brought that up to Mr. Harden without thinking. I figured he already had his errata sheet somewhat put together. But no, we easily have a week to give. So what is today? Wednesday? We can easily give a preliminary due date of next Wednesday. Would that work?
I was going to ask for next Thursday. How's that?
So I only am trying to get them taken care of before the transcripts are completed. So next
Right,
Thursday
okay.
is perfect. I will formalize that tomorrow with a notice order. Are there any other issues or questions before we adjourn today?
Judges Roger Steiner, could we also have till Wednesday or Thursday for the errata sheet? We do not have.
Thursday for everyone.
Got it.
Judge, did I have Mr. Fortson's direct testimony admitted into the record?
You offered 101. It was public and confidential. Yes. Yes.
So it's in.
We'll just do it one more time. Any objections to the admission of Exhibit 101? That is Mr. Fortson's direct, both public and confidential. Hearing no objections, it is so admitted, possibly a second time.
Thank you.
With that, thank you all. I will forward you a WebEx invitation for tomorrow's hearing. We are adjourned and off the record.